Good morning, Mr. Ryan. Can you hear me?
I can hear you, Peter.
Okay, I've got a question for the hearing examiner when he gets his microphone up.
Peter, do you have any estimate on when the hearing might actually wrap today?
Uh, let me, yes, I think mid-afternoon because generally, and I think it's reflected in the cross-exam times, we get towards the end of the hearing and there are fewer and fewer cross-examination questions. So I think when we get down to staff, you can see totals on the staff witnesses are 32 minutes, 37, 42, and then the longest is for Sigler at 55. So I think, and I don't see a lot of questions for my witness, Mr. Brian Andrews. So he's got a total of 35, and people may waive those. I mean, as you see, we get to the end of the hearing.
Yeah, so it could go pretty fast. My question is, since this is my first rodeo, I really don't know what's next. And so I'm just
Okay, what's
trying
next?
to,
Yeah, what's next is there'll be a procedural discussion after we close the hearing in which the hearing examiner will set a briefing schedule. And usually that is dependent upon when we get the transcripts. And my recollection is that P&M has volunteered to do expedited transcripts. So usually it's the first date you have to, is at least 2 weeks after everybody has the full transcripts. And the transcripts will be prepared by Mr. Lee and then put online. And then there'll be a brief, then a chance for a responsive brief. Then after that, usually takes a month or so, there will be a recommended decision by this hearing examiner, which goes to the commissioners. After the hearing examiner issues his recommended decision, there's another process whereby you can take what are called exceptions. And the commission's rules on that are at the New Mexico Administrative Code, which you can find online. But the general code procedures are lined out in 1.2.2. And I think 36, 37 are the post-hearing procedures. So we usually have a shortened period of time for exceptions because everybody's busy. So your exceptions, you say, I disagree with what the hearing examiner said.
right.
And you do another brief. You basically
Right.
quote the record and then it goes to the commission. And
I see. So there's like 2 rounds of summary and then wow, okay, so there's a lot more to go.
well, you can also respond. Like if you agree with the hearing examiner did what he recommends, and I disagree, you can respond to me. So there's lots of chance for back and forth.
Wow, okay. The fun's not over.
No, it actually this is fun, isn't it?
Oh, that certainly is debatable.
No, I mean it's like, man, you have to pay attention. You get to see other attorneys strut their stuff. You get to have a running grade. Okay, this witness didn't convince me. This one did. Yeah, it's cool.
Don't
Peter,
encourage
are you playing
us,
social
Peter.
director this morning?
What's
No.
that?
I
Are you
said, don't
playing social
encourage us,
director this
Peter.
morning?
You weren't here for the Dal Harris show yesterday, Mr. Keith. I missed Mr. Herman.
You leave Dell alone for 5 minutes.
I expected him to start talking about Palo Verde, but I don't know. Inside jokes. Anyway, Mr. Ryan, this is Mr. Gould. I just had a process question.
Sure.
As we have one correction to Mr. Andrews' rebuttal, and we did get a corrected version overnight. It's just one word in the text, and you had noticed it and pointed it out, and we'd addressed it in the supplemental. What is the process? I send everyone after the end of the day a corrected version of his rebuttal.
Plus
And-
the court reporter, and we should do that on the record because we're not yet on the record,
Okay.
but we'll do that for the benefit of Mr. Lee as he's compiling the documents.
And do you also require that we refile it with PRC records? That's my question.
No, because I mean, if it's this is a hearing exhibit, correct?
Yeah, this is just
Yes.
Okay.
So when you filed, serve that on the rest of the parties and myself and Mr. Lee, he will then take that corrected document and then use that in comprising the final transcript of these proceedings, which includes all the exhibits.
okay. Thank you. Appreciate it.
Yeah. And then, I mean, if to the extent you're curious, I mean, what happens back then is that Mr. Lee then supplies to the commission through our paralegal, Ms. Kippenbrock, a giant, packet of files. That's the transcript and all the hearing exhibits, et cetera, and then she uploads them to eDocket, and then you all can then access it off eDocket. So that's how it gets onto the commission's website.
I've done this enough. You think I'd know. I mean,
No, it's the mechanics of it all are always like the devil's in the details, right? Like,
exactly. Okay. Well, thank you. I appreciate that.
okay, it's 9 a.m. Miss Parks in the waiting room. Mr. Lee, let's go on the record here.
Go
All
ahead, sir.
set? Great.
Yes, sir.
We are back. This is day 5 of the P&M Grid Modernization Application hearing. Case number is 22-00058 UT. Commissioner O'Connell is present with us again this morning. Good afternoon or good morning, sir. I see all the parties are present. I'll keep my eye on the waiting room. Before we go back to witness let me do a few things. I know Mr. Gould has something to discuss, but I'll do first. Mr. Gedko, I saw an email yesterday evening to the service list and myself and Mr. Lee. You supplied a corrected version of Miss Lane's testimony.
That's correct.
And if I understand correctly, you've declined to make the correction with respect to consolidating some of that information into a tabular form, and you'll just deal with that in briefing.
Yeah, exactly. It's pointed to in there the information due to its presence in a certified stipulation in another case. And I thought that was sufficient rather than complicating matters.
Sure. And so the only correction that's in the corrected version is you moved that page that was 30 to the correct place in the packet.
That's correct.
Okay. I'm just doing this for the record too, so it's clear.
No, I appreciate it. Thank you.
Mr. Gould, we had a brief discussion and we'll have it on record now.
Yes, thank you, Mr. Hearing Examiner. We have one correction, and we'll get to that when we introduce it, but we have one correction that to Mr. Andrews' rebuttal testimony. And I was just inquiring about the process, and you informed me that I'll file a corrected version if that testimony is admitted into evidence. I'll file a corrected, not file, I'll send a corrected version to yourself, Mr. Lee, and all the parties, and then it will be uploaded as a hearing exhibit, as a corrected exhibit. And Mr. Lee will take care of that. There's no need for me to refile that in the commission's eDocket. That was my real question.
No.
Okay, thank you. Appreciate it.
Anything else before we do go back to witnesses? Okay. I did see Mr. Wilkinson and I admitted him into the Zoom room, and I see his photograph there. So Mr. Bruno, there you are, sir. You may call your witness. Mr. Bruno, I don't think we can hear you. If you appear to be speaking, but we can't hear the words. Mr. Wilkinson, can you confirm that your audio is functioning? Can you say something, sir?
Yes, good morning, Commission. I'm Dick Wilkinson. Nice to meet everyone.
Mr. Bruno, have you repaired your audio?
Commission or Chair of the Commission, if I could, if Mr. Bruno can't recover his audio.
I think I have.
Hey,
There we go.
Sorry about that. All right. It's William Bruno calling Dick Wilkinson. Dick, would you state your name, please?
Wait. Mr. Bruno, we need to have him sworn in. Mr. Lee, would you swear the witness in?
Mr. Wilkinson, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending will be the truth, the whole truth, nothing but the truth, self.
Yes, I do.
Thank you, sir.
Please state your name.
Good morning. My name is Dick Tyler Wilkinson, Jr.
And do you have before you document Bruno Exhibit 1?
Yes,
And do you recognize that as your direct testimony in this case?
yes, I prepared that information.
Okay, so you confirm that you did prepare it.
Correct. Yes.
Do you have any changes or corrections that you need to make at this time?
No.
Would you give the same answers if I asked the same questions today?
Yes, I have not reviewed or learned about any other information that would change my answers since that was prepared.
So everything is true and correct to the best of your belief.
Yes.
I move to admit Bruno Exhibit 1, which is the direct testimony of Dick Wilkinson.
Are there any objections to the admission of Bruno 1? Bruno Exhibit 1's admitted.
I also want to move to admit Exhibit 2, which is Mr. Wilkinson's resume as he provided it earlier in this case.
Okay. And this was exchanged on the Dropbox file exchange service as Bruno Exhibit 2 for the benefit of all the parties in our court reporter. And this is Mr. Wilkinson's resume. And just for the record, Mr. Bruno, just remind me, why is this being submitted as Exhibit 2 and not accompanying as an exhibit to his testimony itself?
I guess there's no good reason. I forgot to attach it in his original direct testimony.
When he originally filed, yes, go ahead, Ms. Padilla.
Mr. Hearing Examiner Leslie Padilla with PNM. I believe this was provided only in response to discovery questions propounded on Mr. Bruno by PNM.
That's my recollection as well. So
That's
Mr. Bruno,
approximately true, but actually the hearing examiner requested it also.
yeah, no, but just for clarity of the record, Mr. Bruno, I believe what occurred, and I think I'm stating the facts totally correctly. You filed Mr. Wilkinson's testimony, did not include his resume or the, what are his qualifications to issue such testimony, and then I discretionarily allowed you to supply that after the fact, and then you did supply that after the fact. So is that, do you agree that's a correct
Yes.
basic statement? Yeah. Ms. Padilla, that comport with your understanding of the events?
Yes, and thank you for clearing that up. Yes, and we would not object to including it and to allowing it to be admitted.
Okay, any objections for anyone else as to the admission of Bruno Exhibit 2, which is Mr. Wilkinson's resume. Okay, Bruno, Exhibit 2 is admitted.
Okay, I tender the witness for any questions.
I know that Ms. Padilla, PNM, has elected to waive any cross of Mr. Wilkinson. Can you just confirm that?
That's correct, Mr. Hearing Examiner. We waive cross on Mr. Wilkinson.
None of the other parties requested cross of Mr. Wilkinson. So Mr. Wilkinson, it's my opportunity just to ask you a few basic questions. How are you doing?
Yes, sir. Good morning. Happy to discuss this with you. Doing well.
Okay, I will say that your audio is a little garbled on my end. It could be a bandwidth issue, but we'll see how this goes. Are you being compensated for your appearance today, Mr. Wilkinson?
No, I am not.
In what capacity? I mean, what is your relationship with Mr. Bruno?
I was solicited by Mr. Bruno to provide this testimony. I did not know him before that request. He found me through just generally public information through my professional, websites and things like that. So he found me, knew that I was here in New Mexico, and thought that I had relevant expertise.
Have you ever testified in front of the commission before?
No, sir, I have not testified in front of this commission.
Have you ever worked in the utility industry?
Yes, I have.
In the utility industry?
Yes, I was most recently the Chief Information Security Officer for the Albuquerque and Bernalillo County Water Authority. So I was in charge of cybersecurity for all of the water services in the greater Bernalillo County area, or, computer security specifically.
Okay.
I'm no longer employed in that position, but I did hold that position recently for about 6 months.
Okay. You said in your testimony, if I recall correctly, computers are computers, and this may actually have been come from Mr. Bruno. I don't remember off the top of my head, but is it your position that these meters that would be installed, that the cybersecurity concerns at issue there are universal to computers?
No, I would not say that. I would not say that.
And why is it unique, and why is it different in some way?
Well, as far as in regards to this device, my professional testimony is based on risk, and the risk I see with these devices specifically is the difference between what would be true, a standard device without an actual computer built into it, or this device which has a small computer built into it. So that's just an automatic increase in risk. When I reviewed other documentation regarding this specific device and the plans for deployment, I did not read enough information that made me feel like that risk had been properly controlled or communicated to potential customers. So that's why I was able to provide this testimony to say that I do believe this increases the risk to a customer of these services.
Do you have knowledge of the varying security standards that are built into these meters when they're designed? We heard testimony in this case about how all of these meters have security parameters built in. You're familiar with those?
Yes, I did read about some of the capabilities that can be employed with these devices when the service provider, being PNM, deploys them. I know the manufacturer is a separate company, and I did research the actual capabilities of these devices in previous deployments, which I saw have happened in other countries as well.
One of the things that was interesting to hear about in this case is, the communication over a home wireless network that would automate the functions of certain appliances. And I used the example at one point in time, you could theoretically program it so that your dishwasher is running only in the middle of the night. And I think as anyone who's spent any time in the utility sector realizes, in the middle of the night, the load curve drops dramatically and there's much less demand because
Sure,
everyone's asleep.
sure.
I mean, do the security concerns you're here today to talk about apply with equal amount to those devices that are in a home? Are they the same effective risk vector, for lack of a better word?
If we're talking about the attack vector, thank you. That's a good term. I appreciate that term, sir. The idea that a hacker could attack a piece of equipment in your home over your Wi-Fi network, yet they all take on similar angles or avenues of attack. They do. So if someone wanted to attack your Wi-Fi enabled dishwasher, they could use some of the same tools or techniques that they would use against your dishwasher against this device on your home that monitors your electricity or manages your power usage. The difference there would be, of course, each manufacturer does build in different security capabilities, so you can't compare apples to apples directly there. And also the risk associated. If your own dishwasher is disabled, that's not as big of a risk, whereas the electrical service being discontinued or disrupted by a malicious actor, I think presents a significantly different risk to the customer.
Okay, I think that's all of my questions. Thank you, Mr. Wilkinson, for appearing today.
Thank you, sir.
Mr. Hearing Examiner?
Yes, Ms. Padilla.
Leslie Padilla again on behalf of PNM. I think we may need to consider whether we do have an objection to Mr. Wilkinson's resume. That you asked him about whether he had worked for a utility and he responded yes. That's not reflected on the document that Mr. Bruno submitted. So now I wonder whether it is in fact an accurate, it's clearly not accurate or up to date. So I think maybe BNM does object to the admission of that into evidence.
Okay, let's just do this real quickly. I have Mr. Wilkinson's resume up on screen too. So Mr. Wilkinson, since you're here with us today, I asked you earlier if you'd worked in the utility industry, you said yes. And so let's go through this. Program management, cybersecurity, technical intelligence, career history, CTO Labs, New Mexico Supreme Court, New Mexico Supreme Court. Well,
I can confirm, sir, that work experience is not on this document, and that was a timing consideration. When I was first solicited by Mr. Bruno, I was working in that, at the Water Authority. I knew that I would be departing soon, and I knew that I would be giving this testimony after I departed. I provided him with a resume that did not reflect that information to prevent any conflict of interest that I may experience by providing the testimony, with that employer. I was aware that I was already leaving, but if that creates a problem for the record, I understand why it would. And the information is not reflected on this document, but it is public record and it's available. I was a government employee.
Ms. Padilla, what is your position here? Are you objecting to the admission of Exhibit 2?
I think we would, just because I don't know that we don't know now that it is completely trustworthy.
Yeah, I agree with you on that count. Mr. Wilkinson, I can appreciate your explanation, but when you're going to supply testimony to a adjudicatory authority, you have to supply documents. This is more for Mr. Bruno than anything. So I will not allow the admission of Bruno Exhibit 2 in light of the fact that the witness has stated that it is not a correct demonstration of his career history and experience. So only Bruno Exhibit 1 is admitted.
Good thing it was a separate exhibit, I guess.
Anything further for Mr. Wilkinson? Thank you, Mr. Wilkinson.
Thank you, Commission. Thank you, Chair. Appreciate that. Have a good day.
Okay, we had Mr. Teague yesterday, Mr. Bartel, and we are on to Mr. Chris. Is he with us?
Yes, I think so.
Ah,
I
there
see
you
his
are.
name
Very
in
good.
the Waiting
Perfect.
room. At this time, Walmart would call Stephen Chris and ask that he be sworn.
Mr. Lee,
Mr. Chris, would you raise your right hand? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, nothing but the truth?
Yes,
Thank you, sir.
Would you please state your full name?
my full name is Steve W. Chris, Chriss.
And by whom are you employed?
I'm employed by Walmart Inc.
Do you have before you a copy of what we have marked as a WM1, Walmart 1, which is the direct testimony and exhibits of Steve W. Chris on behalf of Walmart Inc.?
Yes,
Did you prepare this document?
yes,
Do you need to make any corrections or changes to it this morning?
no,
Do you adopt this exhibit WM-1 as your direct testimony in this case?
yes,
I move the admission of WM-1.
any objection to the admission of this document? Hearing none, Walmart Exhibit 1 is admitted.
Mr. Chris, you have before you a copy of what we have marked as WM3, Walmart 3.
yes,
That document is entitled Supplemental Testimony of Steve W. Chris on behalf of Walmart Inc. in response to February 24, 2023 bid requests, correct?
that's correct.
Did you prepare this document?
Yes,
Do you need to make any changes or corrections to it?
no,
Do you adopt the additional testimony set forth herein as sworn testimony in this matter?
Yes.
I move the admission of WM3.
Any objections? WM3 is admitted.
And I would pass the witness for any cross-examination.
Mr. Albright, I believe you're the only person who requested, or the only intervener who requested cross-examination of Mr. Chris, and you indicated 10 minutes. Is that correct?
Yes, sir, that's correct.
Very good. Go ahead.
Good morning, Mr. Chris.
good morning.
As you may recall from years past, I am with J. Albright Law LLC and represent Bernalillo County in this proceeding. So I do have a few questions related to your direct testimony. Just by way of background, if you'll turn to page 4, please. And again, that's of your direct testimony.
I'm there.
Okay. The outages that you refer to in lines 9 through 14 with regard to service outages at a site served by P&M. I was trying to get a feel for when those outages were. It wasn't quite, just had an internal alarm data shows. And can you explain when those were? And maybe they were in your SWC-2 spreadsheet, but I wasn't sure the timing of those outages. When did they occur?
So I would need to go back and pull that data. So what we have is an alarm system that when the power goes out, it sends an alarm to the receiving system and says, hey, power's out. And then our power restoration team steps into action to see what different mitigations are needed to manage through the outage. And then at some point it does indicate, you know, the alarm clears and indicates that the power is back on. I'm subject to, you know, Mr. Bartel's advice around process, happy to submit that as a late filed exhibit or, you know, as appropriate in the docket. But I don't have that in front of me or in my testimony. So
Okay, fair enough.
but happy to do that.
I was trying to relate that, if you'll turn to page 5, I was trying to relate that to the information or the request that you have in lines 10 through 15. And with regard to the SAIDI and the SAFI, and that's for Mr. Lee, that's SAIDI and SAIFI performance metrics for the period of 2018 through 2022. Have I correctly referenced that in your testimony there?
That's correct.
Okay, so is that information for that period of time retrospectively information that PNM would likely have available? Do you know?
I mean, PNM would need to answer the question directly, but in my experience with other utilities, that information is available.
Okay, and you have their calculations showing changes both from the baseline and year over year from the previous year. Could you just amplify what you mean by that a little bit?
So, you know, one of the challenges of dealing with a 2018 to 2022 number is that's a broad average over 5 years. Obviously, every year is going to have different performance, but one of the things that the use of the 5-year average obscures is whether or not performance has gotten better or worse. It's just an average, and so, I mean, and performance could have stayed exactly the same every year. So, you know, because there's two things going on. I mean, ultimately, you know, you certainly don't want performance to go down relative to how it's been historically. But the other thing is that we do want to make sure that performance is improving, because that's, at the end of the day, you know, from a customer perspective, our expectation is that the grid performs better due to what the utility is doing. So that's why that year over year piece is important as well. Obviously, there's going to be major events, or there are going to be things that are outside the utility's control, and you know, and those are so noted. But within that, you know, how's the system performing on a day-to-day basis? You know, it's important to us as a customer, and so, you know, we want to make sure that that data is out there and knowable and can be acted upon. Because if you can, you know, the whole of you can measure it, you can manage it, you know, line of thinking. So we just want to make sure that things are being managed.
Okay, and on page 8, you speak about proposing 2 sets of evaluation metrics, one for the AMI deployment and one for distribution automation technology. Is that correct?
That's correct.
Okay.
Well, I discussed the company's proposal. That's not Walmart's proposal.
I'm sorry?
Oh, the portion of my testimony you mentioned is the company's proposed metrics, not Walmart's proposed metrics. Sorry if I misunderstood your question.
Okay. And have you had experience in other jurisdictions with AMI metrics and AMI deployment?
Not with the metrics piece. For the most part, you know, the typical operation is the utility gets approval to do AMI and then deploys it. And then actually we move pretty quickly to what Mr. Teague talked about yesterday, which is data acquisition. So, and I don't recall sitting here whether or not any utilities have any sort of performance metrics around AMI deployment. So I'm not sure how. It may be more common than I'm remembering, but I don't remember any specific instances at this time that there were, you know, deployment metrics around it that where the commission was saying, you know, you've accomplished. You know, different time in different time frames.
Okay, and your answer is you're referring to other jurisdictions. I'm referring to jurisdictions other than in New Mexico.
Correct. Yeah.
Okay. In page 9, with regard to the GMR, and again, for Mr. Lee, the grid modernization rider, I believe. Your request there is that it be based on the projected revenue requirement for the upcoming rate year. And after the initial year, a true up of actuals. Do you see that testimony at the bottom of page 9?
Yes, and just for, to be clear, that is my understanding of the company's proposal.
Okay,
That's not Walmart's proposal.
all right. I was going to say, how does that affect, Walmart?
Well, I mean, ultimately, it's the Walmart as a customer. We have a new rider we have to pay. I think it's probably more of a rate case issue. But as we look at, projected test year riders that have true ups, that certainly goes to consideration of return on equity and those rate case factors. But that would be something that we would discuss in the other docket, not over here necessarily.
And just for clarification, on page 10, when you do mention the company's proposed allocation of GMR costs at the bottom of page 10, you make reference to case number 1600276-UT. Do you see that?
That's correct.
You have the following sentence there in lines 18, 19, 20. Additionally, the company proposes to update the allocators to reflect allocators approved in subsequent rate cases. Do you see that?
Yes.
You recall that 1600276-UT was a stipulated case and that the allocators were from the previous rate case?
I recall that it was stipulated. The specific allocation piece, just sitting here today, I don't recall.
Okay. And so approved in subsequent rate cases, there is currently a rate case before the commission 22-00270-UT. So are you including that case with regard to updating the allocators? That they should be updated in the 22-00270-UT case?
Yes, to the extent that the commission approves allocators different from those already in effect as part of the ongoing rate case, that would then apply to the GMR. That would make sense to have alignment, across the utilities assets, in terms of allocation.
Okay, thank you, Mr. Chris. Mr. Herring-Zimmerman, that's all the questions I have. So again, thank you very much, Mr. Chris, for your responses to the questions.
You're welcome.
Mr. Bartel, any redirect for Mr. Chris?
Mr. Chris, turning our attention back to page 4, excuse me, where the question was posed as to what time frame the outages data reflects. In your answer on page 4 to that question, you indicate that 19 of your facilities experienced outages in 2022. Is the information that we see on the exhibit SWC-2 all reflective of outages that occurred in the calendar year of 2022?
That's correct.
And so the additional backup data that you talked about, what exactly would that demonstrate other than these happened in 2022?
So that would have the specific start and end times of the outages. I did not include that data in Exhibit SWC-2. So if it started at 10 a.m., finished at 10:03 a.m., that would be that information.
And I'm
the day of the
assuming,
year.
and would have a day of the year. Okay. All right.
Yeah. And so, we have that data. I just didn't include it.
Right. It's the supporting data for the exhibit, in other words.
Correct.
Nothing further.
Okay, with that, Mr. Chris, your time with us has come to a close. Thank you for appearing today and thank you for your testimony.
Thank you.
Mr. Harriger is in the waiting room. I'm going to admit him.
Mr. Harriger, would you raise your right hand, please? Or I'm sorry, Judge, go ahead.
Yeah, it's okay. Mr. Herman, can you call your witness?
Yes, thank you, Mr. Examiner. Just adjusting my blinds because the sun is about to hit me at a very uncomfortable angle. The Water Authority, the Albuquerque Bernalillo County Water Utility Authority now calls Mr. Andrew Harriger.
Mr. Lee, if you could swear him in.
Mr. Harriger, if you'd raise your right hand. You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Good morning, Mr. Harriger.
Good morning.
Could you please state your name, place of employment, and title?
Yes, my name is Andrew K. Harriger. My place of employment is Solvell and Associates Incorporated, and my position there is a consultant.
And you have in front of you what's been labeled ABCWA Exhibit 1?
I do.
Could you please identify that?
Yes, that's my rebuttal testimony in this case.
And was this prepared by you or under your direction?
It was.
And do you have any additions or corrections to make?
Yes, I do. The first one is on page 8, line 17. Right before footnote 5, there's a stray parentheses there, minor correction. On page 12, on line 6, that reference there was corrected. It should be a 3 instead of a 4. Page 3 in Chan's testimony, direct testimony.
I'm sorry, can you repeat that? This is Julie Park from the city.
Sure,
Hall.
yes. On line 6 of page 12, it's a reference to Stella Chan's direct testimony, PNM witness Stella Chan.
Yes.
That should be a page 3 instead of page 4.
Oh, got it. Thank you.
Page 13, and really this affects 14 as well, but the footnote 9 at the bottom of the page was moved from the footer of page 14. So that was added to the bottom of page 13, which corresponds with line 22, where footnote 9 is. And likewise, page 14, the footnote there has been removed because it was moved to page 13.
Okay. With those corrections, if I asked you these questions today, would your answers remain the same?
Yes, they would.
This time I will move to admit ABCWA Exhibit 1.
Any objections? ABCWUA is Exhibit 1 is admitted.
And I now offer Mr. Harriger for cross-examination.
PNM has waived its 15 minutes with Mr. Harriger. Ms. Park, you requested 10 minutes.
Thank you. Good morning, Mr. Harriger.
Good morning.
So let me see here. It is your position that PNM's class allocation of cost methodology is appropriate for use in this case, correct?
Yes.
And you understand that these are projected costs that PNM is using, correct?
Yes.
Let me turn your attention to page 9 of your rebuttal. And near the bottom, so on line 18, you ask what allocation factors are being used by PNM to allocate grid mod costs to customers. Do you see that?
Yes, I do.
And you list a number of allocation factors, and that goes to the top of page 10, correct?
Correct.
So I'm going to start with the NCP allocator. You begin discussion of that on line 14 on page 10.
Sorry, what line was that?
I'm sorry, line 14, you ask, what is the
Oh,
purpose?
14. Okay. Yes, I see it.
Okay. And on line number 19 of the same page, you explain this allocator is important because the NCP demand of customers can drive the need for additional distribution system investment to meet the demands of individual customer class peak demands, correct?
Correct.
And would you agree that the inputs for these allocators came from 2015? The 2015 rate case that was litigated by PNM and others.
Yes.
And then if you go to page 11, on line 1, you ask what is the purpose of the WTD METE allocator. Do you see that?
Yes.
And you state on line 5, beginning on line 5, the WTD METE allocator weighs the number of customers for each customer class using the marginal capital cost per meters for each class. Do you see that?
Yes, I do.
And the inputs and the data for this allocator also came from 2015, correct?
That's correct.
So you understand that there was a weighted, so let's just go to this line where you say this allocator weights the number of customers. Can you tell us how the weighted meter allocation is calculated?
Yeah, so the weighted meter allocation, it starts with the number of customers, and then you have the cost of the meters. So typically in a weighted meter allocation method, you use typically residential, as your one weighting, and then everything going up from there is then divided by that meter cost for residential. So for example, if a residential meter cost is $500, and then let's say a commercial meter is $1,000, well, then that weighting factor is 2. So then it takes that 2 and multiplies that times the number of customers in that class. And then it takes all of those summed up together to determine the percentage allocation using that weighted meter factor.
How are the weights calculated?
How are the weights calculated?
Yes.
By dividing the costs of the meters at different rate classes by the residential.
Were the costs of the AMI meters in this case by rate class used?
Sorry, can you repeat that?
Sure. Were the costs of the AMI meters by rate class used? The AMI meters in this case by rate class used?
No, I don't believe so.
I just have a couple more questions. So you also talk about cost causation in your rebuttal, is that correct?
Correct.
Would you agree that a lot of the costs, much of the costs in this case, or let me repeat that, the application, this grid modernization application by PNM is driven by state policy directives or decisions? Would you agree with that statement?
I would say some of the costs, but the core components of, let's say, meters are replacing costs that are, I mean, they're needed regardless of policy. You need to have meters. So if you're replacing those, I wouldn't say that 100% of that is driven by policy, at least how the costs affect customers.
Okay. So if you go back to page 11, I just have one last question. At the bottom there, you say, starting on line 20, PNM proposes to use the last commission-approved methodology for allocating distribution and customer costs according to the purpose, function, and benefit of the grid modernization investments. Could you please explain that sentence and what your understanding of it is?
I'm gonna object I would just note that that is a quote from PNM's witness Chan's testimony.
Okay, Miss Park.
I'm just asking, I mean, he put it in here, so I'm asking what his understanding of it is. I think
Okay,
it's-
yeah, overruled. Go ahead. He can answer the question to the extent to which he understands it.
Yeah.
Sure. So my understanding is PNM is using the allocation methods that were used in the 2015 case that were, in their opinion, accepted in the 2016 case through the stipulation, even though, yeah, and I understand I've heard the testimony up to this point, and I participated in that case, so I'm fairly familiar with it. So they're using the allocation methods that were used in the 2015 case.
And do you agree that PNM is using a PNM approved methodology from that case?
Yeah, so I would say that from an allocation standpoint, regardless of what happens at the end of a case, if parties aren't objecting to the allocation methodology, because you have to have a starting point typically. So even in the 2016 case, the starting point was allocation. So even if there was banding and there was other agreements made at the end of the case, from a pure cost of service standpoint, you have to have a starting point. And, if you're using allocation methods in those cases, that's what should be used, going forward, in the case.
Okay, I have no further questions. Thank you. Thank you, Mr. Herringer.
Thank you.
Commissioner O'Connell, do you have any questions for this witness?
Thanks, but no.
Mr. Herringer, how are you, sir?
Good. How are you?
Were you able to listen to Dr. Blank's testimony yesterday?
Yes.
So I asked him, and this was in his direct testimony. I don't need you to go there. He says, I recommend that the commission mandate the use of base rate revenue allocation ratios based on the most recent rate case decision. And, I asked him to sort of lay out what exactly he meant by that, given that class cost of service studies and the way these allocations all work, it gets endlessly complicated in my view. I mean, my experience anyway.
Yeah.
So I guess I want to just ask you, it seems like you and Dr. Blank disagree about this point. Is that right?
Yeah, that's correct.
So can you explain why Dr. Blank is wrong and why PNM's proposal here is better? And obviously this is in your testimony too, but I just want to give you an opportunity, as I gave Dr. Blank, to kind of lay out in a plain language kind of way why PNM's proposal is superior.
Sure. Thank you. So I would start off by saying I do agree that using the most recent case allocation methods is appropriate. It's unfortunate that the way the rate case is laid out, that may not line up, at least with the start, if this is approved. But I do think it's important to stick to cost of service methodology, especially if approved as a rider, that, this has been mentioned by others in this case so far, but when you get into a rate case, like you said, there's a lot of other factors that come in. There's a lot of other policy decisions that affect the final result. But the starting point, in my experience from doing cost of service, you always want to start with allocation. And if you're applying what may or may not come out of a rate case, and applying that to collection of costs through a rider, which is supposed to be more of a, with the true up, you're supposed to be collecting as best as possible accurate costs. And if you start applying, what comes out of a rate case to that, well, then you're mixing up, I'm sure if you've seen the past rate cases with PNM, the end result with the banding and because of, rate shock and other reasons, cost of service is not applied in the end. I mean, they can't just because of, other policy decisions. So I feel like it's troubling to move that into a rider and apply that same, whatever may come out of that rate case to a rider. So I think it's better to stick to cost of service. And I think that's, what our position is. And my position in advising the water authority in the past, I help them with whatever they can to, okay, this is how, you running your pumps at this time of day is going to affect the next allocation and the next rate case. I think that's important. So to me, even though it may or may not come out in our favor, I think it's best to stick to cost of service, especially if it's in a rider. And then if it gets rolled into a base rate case, if that's the method that's approved, then allocation can be done and then policy can be, affect the end result. But I think it's best to stick to cost of service, especially if it's being done in the rider.
So when you keep saying cost of service, can you just explain again, using just sort of whatever plain language you can marshal, the proposal by PNM here, is that closer to the cost of service for specifically distribution level investments and how those investments are utilized? Is that the concept?
Well, I think I'd start with the meters first. And to me, the meters are kind of a no-brainer. Now, what Ms. Park, mentioned about, should you consider the actual costs and there's projections being done? I agree with that should be considered. To me, the methodology in the end is the best approach. And I know PNM, from my understanding of their testimony, they're trying to look, this was in a rate case, this was approved in a rate case. So we don't have more controversy over how we're applying this. We're going to use that. In my opinion, the better approach would be to have the most current rate case, but then also apply, what the cost of those meters are to develop the weighting meter factors. But, if that's not available at this time, then the next best thing is to use, the allocation methods that they were using in an approved rate case. So that's just on the meter costs, which the meter costs are a large piece of this. So from a capital investment standpoint. So, to me, that one's pretty straightforward. I know you can argue that policy decisions are what's driving the replacement of the meters. I get that. And, I think Dr. Blank may have mentioned this, talking about, well, what about a minimum size method on the meter? And I'm not really in opposition to that either. Is there a way to say, well, your typical meter, if it was an AMI is this, and then you use something, that's more novel, but that has been applied on the distribution system allocation. So that's on the meter side. So the meter side, I think, weighted meters a better way to go. On the other ones, you look at cost of service principle, a lot of this, there's a reason why there's only a few books that most experts reference in the last 50 years. Because it hasn't changed a lot. Now, have some of the technologies changed? Yes, they have. And like customer energy management platform, if that's on the distribution level, there could be an argument. Well, you say, you're managing energy. So why would you allocate that based on NCP? Well, that's the established methodology as to how you account for who is using the distribution system. So there may be some flexibility there on some parts of the costs. But that's also treading new ground. So I wouldn't say I'm 100% opposed to that, but I personally try to stick to, established principles, and that's what I default to.
Okay, well, I'll have to think about all that for some time. That's basically my question. And really only questions that I had for Mr. Harriger. Mr. Herman, do you wish to engage with any redirect?
Your Honor?
Yeah.
I hadn't reserved any time, but would I be able to ask just a couple questions?
Mr. Herman, do are you all right with that?
What is this regarding, Mr. Gedko? Is this regarding the hearing examiner's questions?
Yes, regarding the class cost of service studies.
I won't object.
All right, Mr. Gedko, go ahead. I mean, it's right. Mr. Herman's asking, what is the scope of recross? It's laid out pretty clearly. You're not meant to have another opportunity at cross. You're meant to have an opportunity to follow up on questions that I asked. So to the extent to which you're going to do that, feel free to do so.
With respect to class cost of service studies, Mr. Harriger, can reasonable people disagree regarding the appropriate allocation methods used in a class cost of service study?
Yes. Yes.
And due to that ability for reasonable people to disagree, are ranges of reasonable allocation methods developed that are sometimes referred to in the industry as like a zone of reasonableness?
I'm not aware of that term, cost of service, no.
Okay, avoiding that, would you agree that there sometimes are ranges of reasonable allocation methods for a particular category of cost?
In certain categories, possibly, yes. Mhm. Yeah.
Okay, that's all I wanted to ask. Thank you.
Thank you.
Mr. Herman?
I just had one brief item I wanted to clarify. Mr. Harriger, you used the acronym NCP. Could you just identify that for the benefit of the court reporter?
Sure. NCP is non-coincident peak demand.
Thank you. That's all I have.
Hey, thank you, Mr. Harriger, for your time today. Appreciate your contributions to the case.
Thank you.
Mr. Gould, we're up to New Mexico area, and I'm not sure I see Mr. Andrews. Is he here?
I thought he was in the waiting room. I just spoke to him.
Oh, he is. Here we go. So let's admit him. Well, let me ask this question. I might be just Mr. Lee, would you care for a break, sir?
Yes, sir.
Let's do a break. We'll come back in 10 minutes. We're not in any big rush here today. So
Thank you.
Yep. 10:05.
Can anyone hear me? I'm unable to hear anyone or see anyone.
I can hear you. Oh, Mr. Andrews, we're on a 10-minute break.
Oh, okay, that
This
helps.
is-
Thank you.
Yeah, we should be returning, I think, in about 7 minutes.
Yeah. I think
Okay, great.
Was he came into the room right as he ordered the break, so.
Yep.
Okay, thank you.
Brad, Mr. Borman, can you
Yes,
hear me? Do you know the singer Terry Allen, who lives in Santa Fe but grew up in Lubbock?
I'm not familiar with.
I
Yes,
do,
it's-
Kevin, so I want to know the story.
Well, I love this song that he has, the Beautiful Waitress. And
Oh, yeah.
there's a monologue in it at the end where it's a story about him going into a little cafe and kind of falling in love with the waitress for the half an hour that he's eating. And they have a conversation about how she likes to do art. And she says, I like to draw horses and I'm really good at the body, but I'm not very good at the legs or the head or the tail. And Terry Allen says, well, it sounds to me like you're drawing sausages.
That's right.
And
So,
she says, no, they're horses. And so Mr. Borman has I think it's a horse and it's not a sausage that you've drawn behind you on your board there. And I've been reminded of it all week while watching.
It's, it is a horse. I did not draw it. This is actually a painting from my father-in-law.
oh,
wow. Cool.
is it it's a line drawing or is it a painting?
It's a painting.
Cool.
Well, if
Did
you get
you
a
s-
chance,
Yeah.
Beautiful Waitress by Terry Allen.
Kevin, did you see him last summer when he was in Santa Fe? He sang that.
I for some reason I couldn't make that show. Huh, he sang that, huh?
It was awesome. And then, he actually came on stage when Wilco played at the opera last fall too. It was amazing.
Oh, wow.
Yeah, and all the Wilco guys were just like thrilled. You could tell they were they idolized Terry Allen.
That's neat. That's neat. My partner, she's French, but she came to Texas to do a PhD and ended up living with a guy that went to school in Texas Tech and Lubbock, and she literally fell in love with Terry Allen's voice in a certain way. And so then when we moved here, my standing joke is that it's all just a slow, long path to me losing my partner to a 80-year-old singer-songwriter and artist named Terry Allen.
His wife is a visual artist, I think. Well, he's an artist. He does visual art too, I think, right?
That's right. He does a lot of visual art, and now he's started to mix some of them in some kind of like live performances. And yeah, and I think his wife is a really well-respected actress and such, is my
Oh,
understanding.
that's right. She's an actress. Yeah, very cool. All right, Terry Allen. All the
Nice little connection. All right, well, we've had our little exchange, but I'm gonna get for 2 minutes, or else I'm gonna suffer after a little while if I don't get a little glass of water or something. Thank you. Thanks, Leslie.
Yeah, so. Yeah, I need to text me. I need to get off the phone. Okay, I'll talk to you later. Come on, Maria. Okay. Okay, let me check. Come on. Come on. Come on.
Okay, let's go back on the record.
Yes, sir.
Mr. Gould, you can call your witness.
Thank you, Mr. Hearing Examiner. Anna Maria calls Brian Andrews.
Mr. Lee, if you could please swear him in.
Mr. Andrews, if you'd raise your right hand. You solemnly swear the testimony you're about to give the matter and opinion to be the truth, the whole truth, nothing but the truth.
Yes, I do.
Thank you, sir.
Mr. Andrews, would you state your full name and business address for the record, please?
Brian C. Andrews, and my business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63107.
Who are you employed by and what is your job?
I work for the firm of Brubaker and Associates. I'm a consultant there and my title is associate.
Who are you appearing for in this case?
I'm appearing on behalf of the New Mexico Affordable Reliable Energy Alliance, or NM area.
You have before you a document which has been marked for identification as NM Area Exhibit Number 1, do you not?
Yes, I have it.
Could you identify that document, please?
That is my rebuttal testimony that I filed in this proceeding.
Do you have any corrections to make to that document?
Yes, I do. I have one correction to make.
Could you please state the page number and line number and go through the correction that you have?
Sure. So on page 12 at line 4, near the end of that line, the word does should be doesn't. So the sentence that begins on line 3 would read, the assets in the G&I plant - other function largely include the telecommunications equipment, comma, distribution automation plant that doesn't fit in the distribution plant function, comma, and customer information and analytics costs.
Is that the only correction you have to this document?
Yes, it is.
And with that exception, if I asked you the same questions today, would your answers be the same?
Yes, they would.
And to the best of your knowledge, are those answers still correct?
Yes, they are.
And just for the record, Mr. Lee, for Mr. Lee and the hearing examiner, we will send to the parties at the end of this day's hearing a corrected version of NM Area Exhibit 1 by email. And with that, I would ask for the admission of NM Area Exhibit 1.
Are there any objections? NM Area Exhibit 1 is admitted.
And Mr. Andrews, I now turn your attention to a document that's been marked NM Area Exhibit Number 2. Do you have that in front of you?
I do, yes.
Do you have any corrections? Could you identify what that document is, please?
That is my supplemental testimony filed in response to the hearing examiner's bench request filed on March 8th in this proceeding.
Do you have any corrections to make to that document?
No, I do not.
And if I asked you these same questions today, would your responses be the same?
Yes, they would.
And to the best of your knowledge, are those answers that you've given correct as of today's date?
Yes, they are.
With that, Mr. Hearing Examiner, I'd ask for the admission of Enameria Exhibit 2.
Any objections? Enameria Exhibit 2 is admitted.
Pass the witness for cross-examination. Thank you.
Okay, let's see. PNM has waived. No, let's see. Yes, PNM has waived its time with Mr. Andrews. So Miss Beatles, is she with us?
Yes, I am, and I have
Terrific.
no questions.
Okay. The city of Albuquerque, Ms. Park, you'd requested 10 minutes.
Yes, I just have one question. Good morning, Mr. Andrews.
Good morning, Ms. Park.
Can you turn to page 9 of your rebuttal testimony?
I'm there.
I just wanted to ask you about your statement on line 4. Well, your answer begins on 3. You say the allocation of costs in this proceeding is based on projected costs over the first 6-year period of the plan and the most recently approved allocation factors. Do you see that?
Yes, I do.
Can you just tell us what your understanding is, or, well, let me begin with asking you, when you say most recently approved allocation factors, do you mean that the commission has approved allocation factors? Is that what your part of your statement there is?
It's my understanding that the allocation factors that PNM has proposed to use in this case are the allocation factors that they filed in their 2016 rate case, which the commission approved a stipulation in that case.
And it's and PNM based the allocation factors based on its 2015 case. Is that your understanding?
I'm not entirely clear on that. I believe that PNM used the methodologies that were approved in the 2015 rate case, but then in 2016, they may have used updated data in 2016 based on maybe newer customer counts or updated non-coincident peak demands. At this time, it's not entirely clear to me.
Okay. Do you have a Stella Chan Direct available? I'd like for you to look at Exhibit SC3, page 2 of that exhibit, class allocator summary.
Ms. Park, can you give me just a moment to step away from my desk and get that?
Of
Thank you.
course. Yes.
So you said SC3 at page 2 of 8?
Yes, that's correct.
Okay, I have it.
I just wanted to be clear, the record to be clear. So if you look at line 2 under gross plant, it says total distribution plant meters.
I see that.
And then if you go under Schedule 1 residential, it says 62.94%. Do you see that?
I see that, yes.
Is that the allocation factor you're referring to?
I'm sorry, I don't understand
Okay.
your question.
So go back to your rebuttal, page 9.
Okay.
Answer from 3 to 5. You said you're relying on the most recently approved allocation factors. I was just trying to identify that on the schedule, if it is on the schedule.
So I believe that all of these allocation factors in PNM Exhibit SC-3 on page 2, shown in line 2 for the weighted meters, I believe those would be what were filed in the 2016 rate case.
Okay, so when you say allocation factors, it's these percentages that you're referring to, right?
Correct.
Okay, thanks. That's all the questions I had. Thank you.
You're welcome. Thank you.
Mr. Herman, the Water Utility Authority requested 5 minutes.
I don't have any questions today. Thank you.
Okay. Just one question from me, Mr. Andrews. How are you?
I'm well. How are you?
Good, good. In your supplemental testimony, you explain why ultimately bringing GMR costs, the grid mod rider costs, into rates is not a good idea. And I won't ask you to restate what you say there, but I was wondering if you had a chance to hear what Ms. Crane said yesterday during her testimony about the subject.
I was in and out of Miss Crane's testimony. I don't recall exactly what she may have said about it.
Okay, well, I mean, if I recall correctly, and of course, going to her testimony is the best way to do that, but I'm not going to do that now for purposes of time. You know, if I recall correctly what she said, and this can all be verified later, but her basic point was, you know, with these types of investments we have here, which are really fundamental to the distribution system. I mean, in some ways, these are new investments, but they are very basic investments in many ways. It's perfectly appropriate to roll those into rates eventually, because this is core operation of a utility. And I guess I just wanted you to respond or offer a response to that thought, and why, you know, as you argue in the supplemental and in your rebuttal, it still is just not a good idea to roll these costs into rates.
Sure. So I do not disagree that these investments are core utility investments. My hesitation to have these costs rolled into base rates is due to the level of subsidies that exist within PNM's base rates, and they may exist for a variety of reasons, but largely to mitigate rate shock or to be cognizant of the number of low-income customers in PNM service territory. But to keep these costs in the rider and to allocate them and recover them from customers in accordance with cost causation principles really provides the most economically efficient rate structure to customers to show them how much these investments truly cost, and provides fair recovery of those costs from the customers according to how those costs were incurred.
From the large industrials perspective, who gets, I mean, I don't know the answer to the question, but just answer however you wish. It's not intended to lead you in any way. Do the residential customers get more out of these grid investments than the large industrials? Is there an argument for that in this case?
Certainly, the large industrial customers that would take service at the transmission level voltage, they should see very little to no benefit from these investments. And I would go on to say that most large industrial users are already very sophisticated in their use of energy, rather than a typical residential customer that may not change any of their behavior based on current pricing structures. So I think that a large industrial customer whose energy bills may be one of the largest cost items in their business plan, they necessarily already are sophisticated users and use energy in a way that best suits their business.
Okay, and I think I can extrapolate from that some other thoughts, so I won't dwell on that subject further. That's all the questions I had for you, Mr. Andrews. Thank you.
Can I follow up?
Thank
with
you,
one
Mr.
more
Hearing
cost,
Examiner.
Mr. Hearing?
Sorry, Commissioner O'Connell, we'll have him first.
Oh, okay.
I just wanted to follow up on what you just said, Mr. Andrews. Just, I appreciate the large customers are more sophisticated in their use and management of their energy. Does that mean that they are also agnostic to power quality?
I certainly would not suggest that. An outage for a energy intensive manufacturing process is going to be significantly they certainly want a high level of power quality. An interruption on a large industrial customer is going to have a high cost to that business customer that may not be present for a typical distribution level customer.
Thank you. I was just wanting to make sure I understood that it's not just energy that the large customers are looking at. No further questions.
Thank you, Commissioner. Ms. Park, you're requesting.
I just have one question to follow up on.
Okay, and Mr. Gould, do you have any objection to Ms. Park? Okay, go ahead.
Not at all. Thank you.
Are these large customers, do they utilize distributed energy resources?
I am not certain. I don't know the exact details of every large customer's operation.
How about your general understanding without any specifics?
Again, I don't have the specific answers, but I could speculate that some large customers may have some distributed energy resources on their property, be it solar panels or whatnot.
Okay, thank you.
Thank you.
Nothing further from Mr. Andrews, I assume, or Mr. Gould, did you wish to do redirect?
I just have a couple of questions. If, assuming for the sake of this question, if a transmission level customer has distributed generation on its system, would you expect that constraints on the distribution system would have any impact on that customer as far as supplying or receiving energy from that DER?
I would not expect so. I would expect that if a transmission level customer had a DER on their property, that resource would be behind the meter. And so by the time that any excess generation from that resource would make it out to the grid, it would have to go through the transmission level transmission system first before it got to any downstream distribution level customers.
Thank you. Those are all the questions that I have.
Okay. I believe that's all from Mr. Andrews. Mr. Andrews, thank you for coming today and joining us, and thank you for your testimony.
Yeah, thank you, Mr. Hearing Examiner.
Mr. Borman, we are
Yes.
to you, sir. And I see Mr. Maldine in the waiting room. I'm admitting him now.
All righty, thank you.
So why don't you call him and he should be up on screen.
Staff calls Jonah Malden. Jonah, can you activate your video and unmute yourself?
There we go. Mr. Lee, if you could please swear the witness.
Mr. Maldine, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter up and it should be the truth, whole truth, nothing but the truth?
I do.
Thank you, sir.
Good morning, Mr. Malden.
Good morning.
By whom are you employed and in what capacity?
I'm employed by the Public Regulation Commission Utility Division staff. I am a senior economist within the Accounting Bureau.
As part of your duties in that position, did you review the grid mod application filed in this case by Public Service Company of New Mexico, along with the testimony filed therewith?
Yes, I did.
And based upon that review, did you prepare testimony regarding that application?
I did.
Okay, you should have before you a couple of documents, Staff Exhibit 1 and Staff Exhibits 2. Do you have those documents?
Yes, sir, I do.
Okay, can you identify Staff Exhibit 1?
Staff Exhibit 1 is prepared direct testimony of Jonah B. Malden, dated January 27th, 2023.
And was Staff Exhibit 1 prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to Staff Exhibit 1?
I do not.
If I asked you today the same questions that are set forth in Staff Exhibit 1, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes.
And do you adopt Staff Exhibit 1 as your sworn testimony in this matter?
I do.
Thank you. And you also should have a document marked Staff Exhibit 2. Do you have that?
Yes, I do.
Can you identify that document?
Yes, supplemental testimony of Jonah B. Malden dated March 8th, 2023.
And that Staff Exhibit 2 was prepared in response to a bench request?
Yes, it was.
Okay. And was Staff Exhibit 2 prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to Staff Exhibit 2?
I do not.
If I asked you today the same questions that are set forth in Staff Exhibit 2, would your answers be the same?
They would be.
Are those answers true and correct to the best of your knowledge?
They are.
And do you adopt Staff Exhibit 2 as your sworn testimony in this matter?
Yes, I do.
Mr. Hearing Examiner, at this point, I move admission of Staff Exhibits 1 and 2.
Any objections? Staff Exhibits 1 and 2 are admitted.
Thank you. Mr. Malden is available for cross-examination.
PNM, you've requested 10 minutes.
Yes, thank you, Mr. Hearing Examiner. Good morning, Mr. Malden.
Good morning.
You've made me do a quick deep dive into accounting standards, but I hope on this last day of the hearing, and I hope I won't hold it against you. I will try not to. No, this shouldn't be too difficult. Did you review Eric Morgan's testimony? He's the PNM witness who talks about the timing of the AMI meter deployment.
Yes, I did.
So you know that PNM's plan, as discussed by Mr. Morgan, is that full AMI meter deployment will take approximately 3.5 years, correct?
Yes.
And I think he actually described it sort of like roughly, and Mr. Sanders discussed this too, roughly 1/3 of PNM's customers will have meters replaced in the first year, 1/3 in the second year, 1/3 in the third year, correct?
Yes.
So when we refer to legacy meters, it's kind of a moving target, the way I am thinking of it, that day one of PNM's AMI meter deployment, we're not going to have a bunch of legacy meters. We'll have legacy meters that will accrue and build up over time, correct?
Yes.
Okay. And one of the regulatory assets that PNM is requesting in this case is for the undepreciated investment in those legacy meters as they accrue, correct?
Yes.
Okay. On page 10 of your direct testimony, you might not need to look at it, but it's lines 3 through 5. You recommend that the legacy meters be placed into a regulatory asset and subsequently moved from base rates in PNM's currently pending rate case. That's 22-00270 UT, correct?
Correct.
And that's a little different from PNM's proposal, which would proposes that they be the regulatory asset be treated in PNM's subsequent rate case up in the future, presumably when all of the legacy meters, when all of the AMI meters have been installed, correct?
Yes.
Okay, but under staff's proposal, you would put them in, have them treated, removed from base rates in PNM's currently pending base rate case, and you state that that reg asset should be amortized over 10 years, correct?
That is correct.
Okay. Could you confirm that you're proposing to add this amortization of the reg asset in PNM's currently pending base rate case as well?
Yes, that was my proposal. Yes.
Okay. At what point, well, can you please confirm at which point you recommend putting the legacy meters into the regulatory asset?
It would be at the conclusion of this case.
Okay, once approved in this docket. Okay.
Yes.
On page 19 of your direct testimony, let me find that. Sorry, your rebuttal testimony, I apologize.
Do you mean his supplemental testimony?
Let's, it is page 10 of his direct testimony. I'm sorry. Mr. Modine, on page 10 of your direct testimony at line 9, you state that, quote, staff is not concerned that legacy meters will be in use as AMI meters are rolled out. Could you
I'm sorry,
explain?
is this, you said page 10, line 9?
Line 19, excuse me.
19, okay.
Yeah, I can repeat that too. You say at line 19, staff is not concerned that legacy meters will be in use as AMI meters are rolled out. Could you just explain what you mean by that?
Yes, so I think PNM witness Mr. Sanders kind of stated this pretty well. It is a very unique situation in that if staff's proposal were to be adopted, you know, it is conceivable that legacy meters would be being used, as he said, and replaced in 3 years. So there is the possibility that these legacy meters would be removed from service, not allowed to return on while they're still in use. Staff's principal concern is that the uncertainty with which PNM will come in for this subsequent rate case just does not provide staff with confidence that the double recovery of return of and on AMI as well as legacy meters would occur or would not occur. So our best, what we decided to do was to recommend that they be removed from rate base now in this current pending general rate case because of that uncertainty, and as to not kick the can down the road, so to speak.
Okay. So you do acknowledge that these meters that you're recommending be removed from rate base will continue to be used and useful in serving customers, correct? To a certain portion of them until they're replaced by an actual AMI meter.
Yes, so yeah, a portion of them will, yes.
even perhaps a substantial portion of them for a good period of time, because the rollout, as I said, only in the first year that we're only estimating to replace 1/3 of the meters in the first year, correct?
Yeah,
Okay.
yes.
On page 3, so I just want to talk about the accounting implications that your recommendation might cause for the utility. On page 3, line 6 of your supplemental testimony, you reference at line 6, ASC 980. So I had to look this up because I'm not an accountant, but that stands for Accounting Standards Codification, and that's from the FASB, Federal Accounting Standards Board. Actually, I'm not sure if the F is federal or not. That's correct,
Yes.
right?
Yes.
That ASC is Accounting Standards Codification. And is ASC 980 the full set of accounting standards that applies to regulated entities?
It is the codification that GAAP, generally accepted accounting principles, uses, as well as FASB. So
Okay.
yes.
Okay. I looked more specifically at the accounting standard that specifically speaks about impairment of utility investments. Are you familiar with that standard? It's 980-360-35, impairment of utility investments. Are you familiar with that?
I probably couldn't recall, the specifics off the top of my head, but
Did you look at that standard as you were making your recommendations in this case?
yeah, I did look through 980, but yeah, like I said, specifics I might not be able to recall.
So let me just be clear though, did you look at the language in 980 that specifically speaks to impairment of utility investments?
Yeah, in my review, yes, I
Okay.
do remember looking at the language.
And are you aware then that your proposal of moving the legacy meters to a regulatory asset while they're still in service and receiving no return on investment for that reg asset could result in an impairment of the asset and require the utility PNM to incur a write-off of that portion of the legacy meters?
I would say yes, but again, I would highlight the uniqueness of this situation, and really it's difficult with the timing of everything to, perfectly time or account for just the general uniqueness of the situation, but yes.
One thing that I found interesting, I was looking into this issue of the accounting standards about impairment, is that I read, and maybe you agree, that in recent years, the electric utility power supply model is rapidly changing as technological and political forces really change the framework under which we're operating, the energy transition. You're aware, correct, that the commission ordered PNM to make this application to implement advanced metering infrastructure, correct?
I'm sorry, can you repeat the question?
Yeah, you're aware, aren't you, that the commission ordered PNM last March to make this application for advanced metering infrastructure?
Yes, I am aware.
Okay. Those are all the questions I had. Thank you. Thank you so much, Mr. Malden.
Thank you.
It's Beatles. You've requested 5 minutes.
Yes, thank you. Sorry about the lighting. Good morning, Mr. Malden.
Morning.
Would you generally agree that the commission must balance the interest of both ratepayers and investors in regulating utilities?
Yes, I would agree.
And would you also agree that good regulation involves requiring the utilities to bear some risk of cost recovery?
Yes, I would agree.
And would you also agree that whether a utility recovers any stranded investment is up to the commission?
Yes.
And would you also agree that how a utility recovers any stranded investment, whether through base rates or whether through a rider, for example, would you also agree that that's up to the commission, meaning subject to commission approval?
Yes.
And that whether a utility gets a return on the recovery of stranded investment is up to the commission.
Yes.
And how that return is set is up to the commission, right?
Yes, agreed.
Yeah. Okay, I have no further questions. Thank you.
Mr. Albright, you've requested 7 minutes with Mr. Malden. Am I pronouncing that correctly, Mr. Mald? Is it Maldine or Malden?
Malden.
Malden, thank you.
Yeah.
Good morning, Mr. Malden.
Good morning.
I'm Jeff Albright with J. Albright Law LLC and representing Bernalillo County. Just a few questions, mostly directed toward your direct testimony. You would turn to page 11 of your direct testimony. I just want to get some clarification on a statement that's made there.
Okay, I'm there.
Reference to lines 20 through roughly 25. You state there that according to PNM's forecast, AMI meter installation will not begin until year 2 of the GMR, which will be recovered starting September 1st, 2024. And then you have a footnote there. Are you under the understanding that the AMI meter installation recovery will not begin until later, or are you speaking there of the GMR? You're understanding the GMR will be recovered starting September 1, 2024.
There specifically, I am referring to meter installation and not the GMR.
Not the GMR. Why is it better to include the AMI meter costs in a rate rider instead of including them in base rates?
Well, it's a good question. I wouldn't say, well, I mean, it does reduce the risk for the company to recover it through a rider. Ideally, investments like this would be recovered through base rates, but the statute does allow for either or. So, yeah, I wouldn't say it's better to. Okay, let me kind of back up, but I would probably say that it would be the best practice to recover through a general rate case or base rates rather than a rider. But given that this is, required and it is, novel, it's new, a rider is acceptable for recovery of a program like this.
But as you stated, isn't it true that the GMR, the statute, allows recovery through base rates, correct? As an option for the commission, correct?
As I understand it, yes.
And the legacy meters are currently being recovered through base rates, correct?
Correct.
As with a rider, how does a rider or the residential class impact low income compared to other residential rate payers in the residential class?
Well, I would preface this by saying I'm not an expert in rate design, so this question may be better suited for a staff witness, Mark Tupler, but I would imagine that it does have a more significant impact on low income customers rather than those that are not.
Would you turn to your page 13 of your direct testimony? And toward the bottom, line 17, there's a question, why is the New Mexico customer deposit interest rate a more appropriate carrying cost in this matter? Do you see that question?
What was the page? Sorry.
13 of your prepared direct.
13. Can you give me a line number?
I'm not sure I see that question on Mr. Malden's direct testimony, page 13.
Oh, I'm sorry. I'm sorry. That's on Mr. Tupler's. That's excuse me. That was a question for Mr. Tupler, and I'll ask that when I have no further questions than Mr. Malden. Thank you very much, Mr. Malden, for your answers.
Thank you.
Mr. Herman, you requested 15 minutes with Mr. Malden.
Thank you, Mr. Examiner. That won't be necessary. I'm going to waive my cross, and in the interest of time, I can go ahead and waive my cross for the remainder of staff's witnesses as well.
Thank you so much. Commissioner O'Connell, do you have any questions for this witness?
No, I do not. Thank you.
Mr. Malden, I just wanted to follow up on some matters you described there. I believe you described the circumstance we're confronting here as one that is very unique. Was that your statement?
Yes, it is.
And why is it unique?
Well, it's unique because, for one, it's statutorily required. For two, we're dealing with technological obsolescence. For three, we're dealing with the retirement of an asset early that is currently in base rates.
Yeah, and I understand, and I thought that might be what you'd say. And my question was, PNM proposed an AMI project back in 2015. Mr. Kenny came and told us that this technology and these investments are neither new nor novel and are applied throughout the country. And then we also know, it's a matter of just reading the background literature in this case, that PNM's on the slow side of the ledger here in adoption, very slow side. And we expect, something like, I forget how many million it was, but it was like 60% of the customers in the United States will have smart meters. And then that's going to increase exponentially. How is that unique? That strikes me as vanilla as it gets. The utility is basically obligated to do this. Well, not obligated, because that's not even true. They're permitted to do so by statute and may file an application that includes these things. So I wonder, is it really unique? Or is this just, as Ms. Crane said yesterday, going to be normal for the foreseeable future?
I would say it's unique right now, especially for New Mexico. And I would like to kind of further clarify what is exactly unique. What I'm referring to is just the treatment of legacy meters and AMI meters, and the timing and how that is going to shake out. That's really where the uniqueness comes from, as well as just the novelty of these programs to New Mexico specifically.
Yeah, and I guess I'm just wondering. Okay, go ahead, please. Go ahead.
I would agree that this will be the normal moving forward.
Right. It was Ms. Crane's position too that, grid modernization from her perspective anyway is not something that is a one-time agreement that we have this application and then we meet again in several years, but rather an ongoing and rolling process. And in fact, PNM's own proposal in this case is to meet annually, even more so than recommended by Witness Lane, and discuss these matters, because we are going to, on an ongoing basis, have to revisit how the rollout is going, whether technology has changed, and if the investments will be more or less than was initially anticipated. So I just don't see how that's not a sort of a description of a typical utility practice.
Yeah, yeah, I would agree. I mean, the overall, structure of it is not unique, but there are some unique characteristics within the filing and within how this program is going to fit in and how the technologies are going to be leveraged, as well as, dealing with legacy meters, like I keep saying. Yeah.
Thank you. That's all I was going to ask. I appreciate it. Mr. Baker, you're raising your hand.
Thank you, Mr. Hearing Examiner. Following up on your questions.
Wait, hold on. Mr. Borman, are you amenable to Mr. Baker asking a question?
Well, I guess I don't know what sort of questions he's going to ask, so I don't know.
Right. So, Mr. Baker, just for your information, sir, to be aware, right, this is a kind of a fairness principle that occurs here. You request cross, then you have your chance to ask, and then the commissioner may go, or I may go. But if we were to just keep allowing more and more cross, we would never reach an end. You know what I'm saying?
Absolutely.
So the rule is the scope of your questions here, which you didn't request cross, so technically we're in recross, should be
Correct.
limited to what I have just asked Mr. Malden about. And it sounds like that's where you were headed.
Yes, my question.
So, Mr. Boyman, with that clarification,
Assuming he keeps to, I guess, following up on your question and Mr. Malden's response to your question, I guess I don't have an objection to some limited questions from Mr. Baker.
Mr. Baker, I agree with Mr. Borman, so I'll give you some time to ask him some questions, but keep it in the fair territory.
I will do my best, and you can stop me if I stray.
Okay.
So, Mr. Malden, my question, following up on what the hearing examiner was asking, is it seems to me that if the replacement of legacy meters is agreed to be foundational, then it no longer is unique because it is allowed under legislative rules. Is my understanding of that correct in terms of what's unique and what's sort of allowed?
Yeah, I'd say you're correct. The program itself, AMI itself, is not unique. Just certain circumstances that have arisen throughout the case, I would say, are unique, and dealing with them is something that is going to take some real thinking through. So yes, I would generally agree with what you just said.
Okay, so I have really just one question, and that is if it could be shown that the AMI or AM meters, the smart meters themselves, were not actually foundational to the other segments of the plan. In other words, they were not required to carry out other important parts of the plan. Would that change your ability to pull them in as a regulatory asset?
I don't know if I follow your question. So are you asking about legacy meters not being
No, the
foundational?
creation of a regulatory asset, from my understanding so far has been that once the system or the accounting rules accept the smart meters as a foundational part of the plan, then it's no longer unique. It just becomes an asset, and it's up for discussion whether or not it goes in base rate or wherever you're going to put it. But my question goes to the very head of the assumption that the replacement of the meters is foundational or not. And so if it were shown in other parts of testimony, which are not your area of expertise, I understand, but if it were shown that the actual smart meters themselves are not foundational to the plan, then you might treat them differently.
Yeah, I mean, I suppose that would be possible. I guess from my perspective, it's if they're going into service or if they're not, that's really what's gonna determine the treatment of the meters.
Exactly. So my question would be, more specifically, if the plan had presented a rollout of smart meters that was not including replacement of still functional legacy meters. In other words, if it were only rolling out smart meters as the legacy meters failed or replaced under normal circumstances, then you wouldn't even need to create a regulatory asset. Is that correct?
That is correct, yes.
Okay, thank you. That ties it up for me.
Thank you, Mr. Baker. Mr. Borman, redirect.
Thank you. I do have some really brief redirect. Hope it's brief. Mr. Malden, Mrs. Padilla asked about your recommendation to remove the value of legacy meters from PNM's current rate case. Do you recall that?
Yes, I do.
And if I recall correctly, and she'll correct me if I'm wrong with this, she contrasted that with PNM's proposal to remove these in PNM's subsequent rate case. Is that correct?
Yes.
Okay. Do you know when PNM's subsequent rate case will be filed?
I do not.
Okay.
And with their history, I mean, it could be 3 years, it could be 6 years. I mean, their last rate case was filed 6 years ago around.
And they have not committed to a date for filing the next rate case?
They have not to my knowledge.
Okay, thanks. And then one other topic, you were asked by several individuals about whether or not AMI is unique. Do you recall having those questions posed to you? Maybe I
Yes,
asked.
I do.
Okay. So would it be true at least that AMI is at least new to New Mexico?
Yes, it is. This is the third case in New Mexico. Last of the IOUs in New Mexico. So yes, it is a new program to New Mexico. Yes.
And this commission has yet to approve any AMI program for any of the IOUs in the state.
I believe EPE's case was stipulated and approved. And I believe SPS's is awaiting a recommended decision, or might be, I think recommended decision that yeah.
Okay, that was actually a very poorly worded question on my part. But prior to the current suite of grid modernization cases, the commission has not approved an AMI program. Is that correct?
Correct, yes.
Okay, thank you. I have no further questions.
Okay, that would wrap up Mr. Malden. Thank you, sir, for joining us today. I appreciate your testimony.
Thank you.
Thank you, John.
And we have Mr. Tupler in the waiting room.
Yes, staff calls Mark Tupler.
And he is joining. And when he's on board, Mr. Lee, and you see him, please swear him in. Mr. Tupler, just unmute yourself.
Good morning.
Mr. Tupler, would you raise your right hand? You solemnly swear the testimony you're about to give the matter now pending would be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you, sir.
Good. Is it still morning? Yes. Good morning, Mr. Tupler.
Good morning, Mr. Borman.
By whom are you employed and in what capacity?
I am a senior economist in the utility division of the New Mexico Public Regulation Commission.
As part of your duties in that position, did you review the grid mod application filed in this docket by Public Service Company of New Mexico, along with the testimony they filed with it?
Yes, sir, I did.
And based upon that review, did you prepare testimony regarding that application?
Yes, I did.
Okay. You should have a document marked as Staff Exhibit 3. Can you identify that document?
Let me get there and I will describe it. It is the prepared direct testimony of myself dated January 27, 2023.
Okay, was Staff Exhibit 3 prepared by you or under your supervision?
It was prepared by me.
Okay, do you have any changes or corrections to Staff Exhibit 3?
As the document was uploaded, it's correct.
Okay, so when it was filed, there were edits or excuse me, there were errors and those have been fixed in the.
Yes.
Okay, can you
Yes, sir.
identify what those corrections were?
So as I reviewed, I found 2 immaterial punctuation corrections that have been corrected, as I mentioned, in the uploaded version.
Okay. Let me. Do you know where those corrections are?
I believe on page 11, there is an extra percentage sign.
So
And on
that would
page
be on line 3 of that of page 11.
Yes, I believe that's where it is.
After the 0.81.
Yes, sir.
Okay. And then
I believe on page 24, there's a period that needed to be replaced, or a comma that was replaced with a period.
okay. And those corrections have been made on the version that was uploaded to Dropbox. Is that correct?
Yes, sir.
Okay.
I'm sorry, Mr. Tupper, could you say where that is on page 24? I mean, maybe you did. I just didn't hear it.
Let me get there. Okay, scrolling through, bear with me. So I do have the corrected version, so that would be on page 24, line 11. One-time opt-out fees, period.
So it should be period as it was uploaded, but originally on January 27th, there was a comma there, correct?
Right.
Okay. And those are all the corrections that you have?
Yes, sir.
Okay. So if I asked you today the same questions as are set forth in Staff Exhibit 3, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt Staff Exhibit 3 as your sworn testimony in this matter?
I do.
Thank you. Mr. Hearing Examiner, I move admission of Staff Exhibit 3.
Any objections to staff exhibit 3? Staff exhibit 3 is submitted.
Thank you. Mr. Tupper is available for cross-examination.
We go to P&M as waived cross with Mr. Tupler. Ms. Beatles, you requested 5.
I have no questions. Thank you.
Mr. Albright, you requested 7.
Yes, sir. Good morning, Mr. Tupler.
Good morning, Mr. Albright.
And as you've probably heard before, I'm here on behalf of Bernalillo County. I do have another question with regard to potential correction. If you turn to page 17 of your prepared direct testimony.
17. I'm on 17.
Okay, and at line 7, you have an opt-out rate of 0.03%. And then down in line 13, I believe you have 0.3%. I believe the latter is correct, if I'm not mistaken, on the opt-out rated.
I do
right?
see. I'm sorry.
No, I'm just asking which number is correct. I believe it's the 0.3, but if you can confirm that, that would be good.
I believe it to be the 0.3 as well.
Okay, and related to the, and that would result in approximately 1,700 opt-out customers in the PNM service area, correct?
Yes, sir.
Okay. In looking at the opt-out rate on page 16, I think you correctly state in there that the PNM intends to update the associated fees closer to the completion of the AMI meter deployment. Do you see that language in lines 9 through roughly 13?
Yes, I'm there. I see it.
Okay, why even entertain the opt-out fees that are proposed there in the table at this juncture? I mean, why should the commission even approve those if they're going to be based on later information?
Well, I would believe the later information would be based on actual results, which I think are a more reflective number. They could be lower, it could be higher. The chances of them being 100% correct are not very strong from my experience. Thus, to capture accurate actual rates, you have to rely on actual costs.
And so back to my question, why even entertain the opt-out upfront fees that are listed there? Why should the commission or why should staff even recommend that they entertain those costs in this proceeding if it's based on inaccurate information?
Well, I think just by the nature of projections, there's an inaccuracy potential. These rates are based on costs, which the company has projected or estimated based on their historic experience. And I think that's about as close to the bullseye as we can get at this point.
So is it fair to say that it's information that provides that it is just that it provides information, but it doesn't warrant a commission approval at this juncture or a recommendation by staff to approve those numbers?
Well, my recommendation would be that those projected numbers are as accurate as I can get them. So until we have a better idea of what the actual cost of the opt-out feature, if I can call it that, is, these numbers represent the most accurate projection available.
I'd like you to turn to page 13 of your direct testimony, please.
Page 13, I'm there.
Okay, and it begins on line 17. Why is the New Mexico customer deposit interest rate a more appropriate carrying cost in this matter? Do you see that question?
Yes, sir.
Okay, and I think it's just my lack of expertise, but could you try to explain your answer in terms that somebody with an engineering background that I have could understand, as opposed to a financial background there with regard to the impact on the of the 2-year time frame you mentioned rather than the weighted average cost of capital?
Okay, sure. The basis for my answer in that question is that there's a general accounting principle of matching. So the time frame that these over or under recoveries of the reconciliation of the GMR is a short-term duration thusly, the carrying cost applied to that should be a short-term rate as well. The recommendation of the New Mexico customer deposit rate just makes sense.
And how frequently is that updated?
It is updated annually, if I'm not mistaken, on the first business day of the year.
So would that be updated on a yearly basis then, or are you recommending every 2 years, or how are you tying that to the GMR?
Well, I believe the reconciliation is intended to occur annually. Thus, the annual deposit rate could be utilized there. If it's updated, I'm sorry, if it's reconciled any longer than that, I still think it's an applicable rate.
Okay. I have no further questions, and Mr. Hearing Examiner, I'm going to waive questions for the remaining two staff witnesses as well.
Okay.
So thank you very much, Mr. Tupler. Appreciate your answers.
Thank you.
Mr. Herman, did you waive with regards to Mr. Tupler?
Yes, Mr. Examiner, I waived my cross for all of the remaining witnesses.
Okay, I marked a check there rather than crossing that out. Commissioner O'Connell, any questions for Mr. Tupler?
No questions. Thank you.
Yes, I don't have anything either. So thank you, Mr. Tupler, for your participation in the hearing.
Yes, sir. Thank you.
Judge, could we take a 10-minute break?
Yes, we can. That's fine.
Thank you, Mark.
We're just on a 10-minute break. Mr. LaSalle, the court reporter, wanted a break, so we're giving him that. We'll be back at I don't know, 7 minutes from now or something like that.
Okay, thank you. If you wouldn't mind, are my video and audio all right?
It's fine. Yeah.
Okay, I do have a set of headphones I could use if I need to, but if this is all right, I'll just stick with this.
That's fine. You know,
Okay.
It's been touch and go. Some of the witnesses, there is definitely some feedback that's happened at times. And I know exactly why, I think, but you're not having that problem. So.
Your audio's fine by me.
Thank you, sir. Appreciate it.
When you're ready, Judge.
Sure. I'll wait till a few other people appear on video. There's PNM. All right, well, why don't we get started here? Mr. Lee will go back on the record. And Mr. Borman, please call your next witness.
Mr. Hearing Examiner?
Yes, Mr. Bruno.
I've been noticing that a lot of people haven't used all their time and are actually canceling their cross-examinations. And I'd originally asked for more time with these witnesses, and I wonder if, since we are on time, that I could have the original amounts I asked for.
Ms. Padilla, what do you have to say about that?
I'm trying to remember what the original times requested were. That might help me.
Yeah.
Yeah, sure.
Mr. Hearing Examiner, if it helps, this is Sydney. I waive my cross of the two remaining witnesses who I believe are Mr. LaSalle and Mr. Sidler.
Okay. And then Mr. Bruno, I have my sheet here. You asked for 7 minutes with Mr. LaSalle and 15 minutes with Mr. Sidler. Is that what you'd like?
I was originally had asked for 10 minutes and 20 minutes.
I don't have an objection to that. Is there any party object to this?
I mean, it sounds like that's like an additional, what, 3 minutes for each, or 3 and 5 minutes?
Not much, yeah.
Yeah, it's not significant additional time, so I'm not gonna object to that.
PNM has no objection either.
Okay, Mr. Bruno, ask and you shall receive.
That's what I like to hear.
So, Mr. Borman, call your next witness.
Thank you. Staff calls Eli LaSalle.
Mr. Lee, please swear Mr. LaSalle in.
Mr. LaSalle, would you raise your right hand? You solemnly swear the testimony you're about to give the matter and opinion to be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Thank you.
Good morning, Mr. LaSalle. By whom are you employed and in what capacity?
Yes, I'm employed by the New Mexico Public Regulation Commission staff in the utility division as an engineer intern currently.
As part of your duties in that position, did you review the grid modernization application submitted by Public Service Company of New Mexico and the accompanying testimony?
Yes.
And based upon that review, did you prepare testimony regarding that application?
Yes, I did.
Okay, you should have a document that's marked as Staff Exhibit 4. Do you have that document?
Yes.
Can you identify that document?
Yes, this document is direct testimony prepared by me in this case.
Okay. So that document was prepared by you?
Yes.
Okay. Do you have any changes or corrections to that testimony?
Not that I managed to find, no.
Okay, fair enough. If I asked you today the same questions as are set forth in Staff Exhibit 4, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes.
Do you adopt Staff Exhibit 4 as your sworn testimony in this matter?
Yes, I do.
Thank you. Mr. Hearing Examiner, at this time, I move admission of Staff Exhibit 4.
Any objections? Staff Exhibit 4 is admitted.
Mr. LaSalle is available for cross-examination.
I believe everyone has waived cross, but Mr. Bruno, you requested 10 minutes.
Great. My microphone's working and everything. Well, good morning, Mr. LaSalle.
Good morning, Mr. Bruno.
Okay, so in that exhibit 4 on page 9, line 12, can you heard of that?
Yes, give me just a second to get there, but you said page 9, line 12.
Correct. You said staff believes the proposed grid mod projects will provide significant enough benefits to the public to justify the program costs proposed. Is that correct?
Yes, sir.
When it says staff, when you said staff, did you mean you speaking with the authority of staff, or does it mean staff made a collective judgment?
I believe that all I'm saying there is that that is my belief as staff, speaking on my behalf as a member of staff.
I understand.
And then if other staff witnesses are supportive of that as well, that could be identified by them.
Understood. So you don't mean by this statement, do you, that a quantitative BCA benefit cost analysis was performed by you, does it?
No, sir.
So it's more of a qualitative judgment?
Yes, sir.
So if it turned out that the rider was going to cost $600 a month instead of $6 a month, would you agree that the plan wouldn't be reasonable?
And when you you're referring to a cost that a customer would see, kind of.
Yes.
Yeah, that seems to be a fair statement.
Is it possible that a rider of $6 a month might be reasonable to you, but not reasonable to some of the 16% or more of New Mexican households living in poverty?
I believe that reasonable people can disagree as to what a reasonable cost would be.
Thank you. Could the opting out fee cause some customers' bills to double?
I'm not entirely certain. I don't believe that I addressed the opt-out fee specifically in my testimony.
You're right, I'm sorry.
That's
fine. So now on page 10, line 12 of your testimony.
Yes, line 12.
Right. You're responding to the question, does staff support the depreciation schedules proposed by PNM in this case? You responded, yes, staff finds. Am I speaking too fast for the reporter? I'm sorry.
No, sir, please continue.
You responded, yes, staff finds PNM's utilization of a 20-year depreciation schedule. And then you go on to say their analysis of industry practices and recommendations of their specific meter vendor are the best source of information available. What research did you do to reach that conclusion that those were the best sources of information available?
Yes, in my review, largely I'm relying on information provided by PNM witness Hawkins, citing both to that Edison Electric Institute survey and recommendations from their specific meter vendor, who are the vendor that will be providing, as well as who will be providing those meters to PNM. And I have participated previously in two separate advanced metering cases in New Mexico, those of EPE and SPS. And in those cases, and in the lead up to this hearing. I have reviewed other kind of industry studies and additional documents. I didn't include those in my testimony here, but in general, what I've seen is consistently a depreciable life in the range of 15 to 20 years for advanced meters.
Isn't it true that meter manufacturers could tend to overestimate service life to make the cost seem more reasonable?
That seems like it could be possible, which is one of the reasons that you would want to have something like the utility survey provided by Edison Electric Institute to independently kind of collaborate the estimate provided by the meter vendor.
I'd like to call your attention to two exhibits. Bruno Exhibit 36, do you have access to that?
I don't believe I currently have it on hand.
This might be one that I emailed yesterday.
I do see it emailed to the service list. Do you want me to share this on the screen with Mr. LaSalle?
If he doesn't have it, then yes.
If it wouldn't be a problem, that might be helpful for myself.
Sure.
Thank you, sir.
Are you seeing PPL Electric Utilities? Is this the one?
That's it. So this is actually a trade journal reprint of a newspaper article. And if you go down to the first paragraph there, Allentown-based utility, do we see that? Touted itself as a pioneer when it installed 1.3 million meters from 2002 to 2004. Those meters proved obsolete in just 4 years, failing to meet minimum performance requirements of new state regulations. So do you agree that in this case, the 20-year service life was very inaccurate?
I'm going to object. I mean, I don't think he's established that Mr. LaSalle is familiar with either this article or with the matters that are the subject of this article.
And I would, Mr. Bruno, go ahead and respond. What's your answer to that objection?
Well, I'm happy to ask whether he's familiar with this incident in Pennsylvania.
I think that the objection's understandable, but given that Mr. Bruno is a pro se intervener, the first thing you would need to establish, Mr. Bruno, is that these meters utilized here have a 20-year service life. So I don't know that I see anything about that assertion.
Well, the service life is not something that is in the meter specification. It seems to be something that that is, essentially made up.
Well, I'm talking about you asked Mr. LaSalle, if I understand correctly, that this Allentown-based utility had some meters that had 20-year service lives, and look, they were obsolete much quicker than 20 years. But I don't know that I see any. I mean, I have no clue what these meters are, or that they have 20-year lives.
Well, we know they only lasted 4 years.
Okay.
So that's one data point. I agree that we don't know how long they were expected. Actually, further down, I think in the next sentence, it says, the next paragraph, after half their useful life, it says in the first sentence of the next paragraph.
Mr. Hearing Examiner, this
Yes.
is Leslie Padilla from PNM. I mean, object to this exhibit also, and Mr. Bruno's explanation of it is, I just want to be sure that everyone knows, is not itself evidence. This is a 2014 article. So this is, this is talking about something that occurred almost 10 years ago. So the relevance is also doubtful, in addition to the issues that Mr. Borman raised.
Yeah, I think Mr., you can ask Mr. LaSalle, to read this section and say, yeah, this article says whatever it says. But
Right.
beyond that, I
agree. I mean, the basic, you're trying to establish here, Mr. Bruno, that a utility had some meters and they became obsolete pretty fast, right?
Yes.
Okay, let's just do this. Mr. Borman, do you object to the admission of this document in the record?
I do. It's
okay.
It's not, there's no foundation for it. We haven't established that Mr. LaSalle has not only not used this article in the preparation of his testimony, I don't think he's ever seen it before.
Okay, and I just assumed, Mr. Bruno, you were going to ask me to admit this into evidence. Am I correct to have made that assumption?
Yes.
So the problem here, Mr. Bruno, I've been thinking about this quite a bit. If you wanted to establish that there was a wealth of information around utilities who had previously employed these meters, and then look, they went obsolete immediately. I mean, this was materials that should have been supplied in your case in chief. And I think the foundation objections that I've been getting, as you and Mr. Baker have made some documents, man, I was just thinking through this in my mind, like what's going on with these foundation objections. And I think that's really what the objection is about, is really, I mean, there's a technical part about the foundation. I understand that in the rules of evidence, but more fundamentally, this is material that you should have covered in your case in chief, and that you're trying to admit into evidence now at the hearing. And I mean, I can understand why a person who doesn't participate in these proceedings might not see that as participate with regularity, might not see this as terribly problematic, but like, as I think you've seen through the course of this proceeding, we do everything in advance. And then we come to the hearing and it's just about cross-examination. And the goal of that is administrative efficiency. It is to save you as a taxpayer money and time from actually having a trial that, imagine how much time we would have spent if these people came and all said what they said in their direct testimony. It would go for months. So I mean, I don't know. In my view, Mr. Bruno, I'm not surprised to discover that you found an article that indicates that some meters went obsolete. I mean, one of the major themes of discussion throughout this entire case has been, if the PNM's application is approved for this big implementation period, do we reach year 5 and there's some new technology that's better? So this doesn't surprise me, but I'm not going to admit this exhibit because I think this should have been something you addressed in your direct testimonies. So I will sustain the objections for the reasons that I've just given.
Mr. Hearing Examiner?
Yes, Mr. Gedko.
The only thing I'd like to add is, I think the understanding of foundation is pretty pivotal, because we've seen information admitted. There was a little bit of a discussion about this maybe 2 days ago, with information that I had a general understanding. I learned this on the fly to a degree as well, that maybe should have been presented in the case in chief of the company, but got admitted through what was arguably friendly cross-examination. And so for the edification of all of us and the way that we handle these matters, I would proffer that the foundation is the issue if we're going to follow the precedent that was set in this case a few days ago. And I've struggled with it as well, and I just think it's a helpful discussion for us to see.
Fair enough. Noted for the record, Mr. Gedko. So, Mr. Bruno, back to you. You ran out of time, but I'll give you another 2 minutes here with Mr. LaSalle.
Well, why don't we bring up the next exhibit? I've got to get my screen back the right way.
Yeah, I have to
Oh,
stop
can you
sharing.
stop sharing the screen?
Yes, I can.
I would note that I'm likely to have similar objections on these other exhibits.
Yeah,
Yeah, what, can we just read a little bit of that?
you know, Mr. Bruno, I'm going to say no, and I'm actually going to, at this juncture, just bring this to a close. So I will thank Mr. LaSalle for his time today. Unless, Mr. Borman, you wish to engage in redirect.
I have no redirect from Mr. LaSalle.
Okay, Mr. Borman, call your next witness.
At this time, staff calls Jack Sidler.
Sorry, does that mean that I am dismissed? And
Yes, you are, Mr. LaSalle. Thank you very much.
okay, thank you, sir.
We have Mr. Sidler.
I have to see if I have him in the waiting room. I think I do. Let me admit him. So staff has called Mr. Sidler. He is here. Can you hear us, Mr. Sidler?
Can you hear me?
Your audio is a little weak, but
How about now?
better. Mr. Lee, could you swear him in?
Mr. Sidler, would you raise your right hand? You solemnly swear the testimony you're about to give the matter up and needs to be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Good morning, Mr. Sidler.
Good morning.
By whom are you employed and in what capacity?
The New Mexico Public Regulation Commission as an electrical engineer.
As part of your duties in that position, did you review the grid modernization application submitted by Public Service Company in New Mexico and the testimony that they filed in this case?
Yes, I did.
And based upon that review, did you prepare testimony regarding that application?
Yes, I did.
So now you should have two documents before you, exhibits 5 and 6. Do you have those?
Yes, I do.
Okay, let's talk about exhibit 5 first. Can you identify that document?
That's my prepared direct testimony in this case.
Okay, was staff exhibit 5 prepared by you or under your supervision?
Prepared by me.
Do you have any changes or corrections to that testimony?
No, I don't.
If I asked you today the same questions as are set forth in staff exhibit 5, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt staff exhibit 5 as your sworn testimony in this matter?
Yes, I do.
Mr. Hearing Examiner, I'll do these one at a time this time. I move admission of staff exhibit 5.
Any objections? So staff exhibit 5 will be admitted.
Thank you. And then, Mr. Sidler, you also have staff exhibit 6, correct?
Correct.
Can you identify that document?
That's my supplemental testimony in this case.
Okay, and that was prepared in response to a bench request?
Yes, it was.
Okay, and it was prepared by you or under your supervision?
By me.
Do you have any changes or corrections to staff exhibit 6?
No, I don't.
If I asked you the same questions as are set forth in staff exhibit 6 today, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
You adopt staff exhibit 6 as your sworn testimony in this.
Yes,
matter.
I do.
Thank you. Mr. Hearing Examiner, I move admission of staff exhibit 6.
Any objections? Staff 6 is admitted.
Thank you. Mr. Sidler is available for cross-examination.
Mr. Bruno, you have requested 20 minutes with Mr. Sidler.
Yes, sir. Good morning, Mr. Sidler.
Good morning.
So how many on the PRC staff are trained in electrical engineering?
Basically just me.
And
That has an actual engineering degree,
I see,
electrical degree.
I see. And you're a professional engineer, is that right?
Yes, I am.
Does PRC staff have any experts in FCC compliance?
No, we don't.
So no one on staff undertook to investigate the FCC compliance documents?
No.
Would you mind taking a look at Exhibit 40? Now, this was emailed yesterday, but this came as a response to a discovery request from PNM. Do you have that email?
Yes, I do.
And for the record, this is the Itron Gen 5 Riva single phase electricity meter technical reference guide, which I know at some point was admitted through another witness. I just don't recall offhand who.
I'm not sure that this guide was admitted, but
I thought it was. Does anyone recall? Ms. Padilla, do you know?
I don't recall. I can double check. It probably would have been during the cross-examination of Jonathan Hawkins, but I will have to confirm that.
Okay, well, I might be wrong. Mr. Bruno might be correct too. It might be another document that went in through Mr. There was some technical documents associated with the Gen 5 Rivas I know was admitted, but maybe not this specific one.
Exactly, and I do believe we provided this in response to discovery. I will confirm which response that was, which discovery request that was.
Okay. Go ahead, Mr. Bruno.
Thank you. So if we go to page 11 out of 11 of 145.
Is that document page 11 or PDF page 11?
The document page 11.
The page numbers are on the bottom right of the document.
Yes, I see them. But the PDF doesn't always coincide with the document. Okay.
So the fourth new paragraph on this page starts with the antennas. We see that?
Okay.
The antennas used for this transmitter must be installed to provide a separation distance of at least 20 centimeters from all persons and must not be co-located or operating in conjunction with any other antenna or transmitter. Is that what it says?
That's what it says.
Can we bring up Bruno Exhibit 39?
Okay, I was wondering about this one, Mr. Bruno.
That'd make a nice Facebook picture.
Just for the record, Bruno 39 is a picture of a large teddy bear on what appears to be a plastic chair with its head very close to a meter.
I should have mentioned in Mr. Hawkins' testimony, so I asked him about, so PNM had replied to a discovery about how they were going to comply with this directive of 20 centimeter separation, that they said they couldn't guarantee it. Mr. Sidler, I just wonder if you see a safety problem in this picture.
Mr. Hearing Examiner, this is PNM. I think I need to object to that question. If Mr. Bruno is making assertions about PNM discovery, he should probably show us that discovery. I don't dispute that we did have discovery on this question about distance, but I don't want him to his own assertions to be the record of that. In this case, we should look at our actual response.
Well, that and the fact that it's not really clear what, what sort of meters these are. It's not, there's no, I guess, measuring stick or anything that shows the exact distance. I think it'd be a lot of guesswork on any witness's part to ask questions about this outside of whether or not that's a teddy bear.
Okay, Mr. Bruno, what's your response, sir?
Well, I can bring up Bruno 13 if you want. That's where the discovery is. And
I think, Mr. Bruno, for your benefit, why don't you stick to the questions you wish to ask Mr. Sidler that go to you establishing whatever you're trying to establish here, rather than us focusing. I mean, I presume this picture you presented of the teddy bear is to show a distance of 20 centimeters. Is that what is going on here?
well, in this case, the distance is 0 centimeters.
Okay, this teddy bear's head, I can't tell from the picture that that's the case. I mean, that's partly goes to Mr. Borman's objection. You really can't say what the teddy bear is doing with the meter and whether that's even the same meter. So let's stick to questioning, Mr. Bruno. I'm not trying to limit you in any way. I'm trying to help you utilize your time effectively.
So, Mr. Sidler, as a professional engineer, does this raise concerns for you?
No, teddy bears aren't affected by RF radiation.
That's certainly true. Teddy bear will be fine. But could you imagine a child sitting in that chair?
There isn't one.
Are you telling me that you're thinking that no child will ever sit in that chair?
Nothing stopping them.
So they could actually sit in that chair.
I guess so.
And so then the meter would be at that point deemed to be installed incorrectly.
Mr. Herring, examiner?
Yes.
This is Leslie Padilla from PNM, and I'm looking at your March 14th, 2023 order striking all evidence submitted by PNM bearing on the issues on which New Mexicans for Utility Safety objected. And that is where Mr. Bruno is now going with his questions about, RF interference. And
Mr. Bruno, what's your response?
I think there were witnesses that from PNM that indicated that FCC would be obeyed and meter installation requirements would be followed.
Mr. Hearing examiners, those were some of our discovery responses, I believe, although Mr. Bruno hasn't brought those up. As to the testimony that Mr. Bruno is referring to, we were ordered to strike that in Mr. Hawkins' testimony, and we have done that in Mr. Hawkins' direct testimony.
I'm going to sustain the objection. Mr. Bruno, ask another question.
Yeah, okay. I'm going to have to skip a few questions, it sounds like. All right, so did you hear Mr. Hawkins' verbal testimony on Zoom, Mr. Sidler, this week?
I heard parts of it. I don't recall hearing all of it, but I've heard parts of it.
Do you recall him mentioning older meters that used to use PLC for communications?
Power line carriers, I guess you mean.
Correct.
I know that they're available and they do, but I don't know that much about them.
But do you remember Mr. Hawkins mentioning them?
No.
Are you aware of whether the proposed meter in this case, the Itron Gen 5 Riva meter, uses PLC?
I'm not aware that they do. I'm not aware that they don't.
Can we look at on this exhibit 40, page 44 of 145?
Page 44, not 144, right? Page 44.
44.
Okay.
And the second new paragraph, the second sentence. I read, the peer-to-peer communications can be either power line carrier, PLC, or RF. Do you see that?
Page 44. Now, what paragraph was that?
It's the second new paragraph, the second sentence of that paragraph. The peer-to-peer communications.
I don't see that in that paragraph, to be honest with you, Mr. Bruno. That's paragraph on, you're talking about PDF page 144 of 145?
No, page 44 out of 145.
And this is Bruno exhibit 36?
40.
Okay,
This is the, Mr. Examiner, this is the Riva
Yeah.
Gen 5 Gen single technical reference document.
let me just couldn't verify. We're all looking at the same document. I'll do this. Is this the page that I'm supposed to be looking at?
Yes,
Okay, I see. You're the second full paragraph. Gotcha.
yes, and the second sentence of that paragraph. Right, the peer-to-peer communications can be either power line carrier, PLC, or RF.
Yes, I see that.
That's all we need to see of that document right now. So do you know whether PNM has discussed PLC at all?
I don't recall that they did, but I don't know for sure.
I wish we had the transcript, but I think Mr. Hawkins said PLC was unreliable.
Well, PLC does have its problems. It does not go through transformers very well. And, you know, I think it's very dependent on the wire condition, on the grounding conditions, things like that. I mean, it does have its problems too.
So we don't have any information from PNM about whether they're going to enable PLC. Is that to your knowledge?
I don't know one way or the other. That's PNM's decision.
Thank you. You quote the grid modernization statute saying, and it says, one of the things that is part of a grid module proposal, if you remember, is provide customer protection, information, or education. So I was going to ask, so we talked about ANSI compliance. Is ANSI a government body?
I don't know.
Could it be funded by industry?
It's the American National Standards Institute.
Okay.
I don't know whether it's governmental or whether it's a private agency.
Okay. Is it possible that it's funded by industry money?
I don't know.
When a high voltage transmission line comes in contact accidentally with a lower voltage line, could there be a voltage to the meter in the tens of thousands of volts?
I suppose there could be.
Do you think would it surprise you to learn that the ANSI tests on this meter are no more than 6,000 volts?
I'm sure they test it to whatever they feel is appropriate.
What would you feel is appropriate?
I'm not the one responsible for testing it.
Okay, so you don't have an opinion?
I don't have an opinion, basically.
Are you aware that in 2022, whether ANSI relaxed the standards of C12.10 that apply to electric meters?
Can you repeat that, please?
Are you aware of changes to the ANSI standard in 2022 that relaxed the C12.10 standard?
No, I'm not.
So you wouldn't be aware of any data that justified such a relaxation?
No.
Let's look at Bruno Exhibit 15.
I don't think I have it in front of me.
Okay. Okay, yeah, so if you can read the last sentence of the abstract, which is in bold. Well, so the title, why don't you read the title and then I'll read the fine print. But could you read the title?
Conducted interference on smart meters is the title, but the print's too small for me to read anything else.
Can we make it a little bit bigger, Mr. Hearing Examiner? The abstract.
Try. Yeah, it's tricky because it's sharing screen does funny things.
Whoops.
I don't think so. I'm not my current setup, unfortunately.
Well, anybody else want to read from that fine print? I could read it.
Why don't you go ahead and read it, Mr. Bruno? I'm reading it with you so I can verify what you've read is accurate.
Okay, now positive reading up to plus 582%, negative reading down with minus 32% were registered. So, Mr. Sidler, is it plausible to you that conducted interference could cause errors in smart meter readings?
I would say it's plausible, but I don't know. That's not my field of expertise.
Can we bring up Bruno Exhibit 38? This was an emailed one.
Okay.
So this is a newspaper article. Do you see a picture of a meter in that article?
Yes, I do.
Are you able to read the make and model on that meter?
Looks like an Itron Gen 5.
Gen 5 Riva, do you see
Hey,
Riva?
Gen 5 Riva, yeah.
Okay. And then if you read like the first sentence of the article, sorry, on page 2, the first sentence.
Welch said he has seen his bill triple and quadruple from
All
about.
right, you're breaking up. Can you start again?
Yeah, Welch said he has seen his bill triple and quadruple from about $200 per month to $892.
Can we admit this article into the record?
Certainly not without objection. Again, there's no foundation established here. I mean, this is an article that interviews some individual who says his bills tripled and quadrupled. But we've seen a bunch of people here in New Mexico whose bills have actually increased over the last couple of months, and now actually think they're headed down, that have nothing to do with the meters.
Yeah, I'm going to sustain the objection. I mean, Mr. Bruno, you can respond if you wish, but I think I know what you would say. Unless you want to surprise me and speak, you're free to do so now.
I don't. I'm trying to remember if there was any other exhibits that still. Well, can we admit that technical exhibit?
The Gen 5 Riva
Yes.
document. Ms. Padilla, do you have any objection to that?
No, we don't. I think that would be, that was a response to a Bruno discovery question 2-01. If you look at the bottom on that document, it indicates PNM provided. Of course, it's this technical spec sheet for the meters that we're proposing to use in this case. So no, we have no objection.
Yeah, and then this is useful for the commission too, actually. I'm glad that we've finally got this document. So Bruno, this is Bruno exhibit what, Mr. Bruno?
I think it says on it somewhere, but
I think it was exhibit 40, Dr. Bruno.
That's plausible. We can call it 40 because I don't think I'm gonna run out of numbers at this point.
Right. Okay, so we'll admit the document entitled Gen 5 Riva Single Phase Electricity Meter Technical Reference Guide as Bruno Exhibit 40.
Thank you.
And you've got
And
six
I'll mention,
seconds.
That's not a spec sheet, by the way. That's an instruction manual. We already admitted the spec sheet. I think I'm through with this witness. Thank you.
Okay. Mr. Borman, any redirect with Mr. Sidler?
I do not have any redirect for Mr. Sidler.
Mr.
that
Hearing
brings-
Examiner,
Yes, Mr. Verhul.
I apologize. PNM did not waive cross on Mr. Sidler. We actually did have a couple questions for him, if that's okay.
Yes, that's fine. I see that. I thought that Ms. Padilla had said otherwise, but Mr. Borman, do you mind? That was my oversight.
No, it's obviously if PNM didn't waive it, then they haven't waived it.
Go ahead, Mr. Verhul.
Thank you. And this should be short and just a couple clarification questions. Good afternoon now, Mr. Sidler. My name is John Verhul. I'm a counsel with PNM. And my understanding from your exchange with Mr. Borman earlier is that you have Exhibit 5 with you, which is your direct testimony. Is that correct?
Yes, I do.
I'm going to direct you to page 11, marked page 11 of your testimony. And I'm going to read to you starting on line 13. And I'm going to ask you if I'm getting this right. It is staff's position that PNM's request to install AMI meters, FLISR equipment, and NAN equipment is consistent with the grid modernization statute, as well as the other items requested in this case, and should be approved by the commission, subject to the recommendations of, and then it goes on to name yourself and the other staff witnesses. Is that accurate?
Yes.
And then I'm going to direct you down, starting on line 18 on page 11, to the condition that was specific to your testimony. And again, I'm going to read it to you, and you can tell me if I get it right or not. PNM should be required to pay for and perform all work that may be necessary to replace or repair existing service equipment and associated equipment at customer locations solely to accommodate the installation of the AMI meters, with the ability to recover those costs in a future rate case. PNM should not be required to pay for or replace any equipment that needs to be replaced solely for safety purposes, regardless of the installation of the AMI meters. Is that right?
Yes.
Okay, so my question is about the last sentence in the condition that you put in your testimony, which says PNM should not be required to pay for or replace any equipment that needs to be replaced solely for safety purposes, regardless of the installation of the AMI meters. I wonder if you can elaborate or explain or provide some explanatory examples of the types of equipment costs that you were thinking of when you said that.
Well, I mean, one cost would be the meter box itself.
Okay.
The property owner, and I'm going to say property owner because the customer doesn't necessarily own the equipment, but the property owner owns the meter box that the meter is plugged into. Hence, any repairs that are required to that meter box are at the customer's expense and their responsibility to do it. I mean, a car hits it, conduit pulls loose. There's various problems that wouldn't meet the safety codes of the National Electrical Safety, or the National Electrical Code, which is what it would be under. But that an inspector on an inspection wouldn't approve it. In that case, it would be up to the customer to fix it, in my opinion, because it's not it's not right to require the ratepayers of PNM to pay to fix somebody else's property, if it would have required fixing already. But if you go out to install the meter and discover for some reason the meter doesn't quite fit, and you want to install the box, that you have to replace the box, then that's on you because that's part of your project. That meter box may not need replaced or repaired if it wasn't for you changing the meter.
And with respect to that last example, you're talking about when PNM goes out to install the AMI meters.
Basically, yes.
Okay. All right. Well, that is very helpful, and I appreciate the clarification. PNM has no other questions for this witness.
Thank you, Mr. Verhul. Mr. Borman, any redirect based on Mr. Verhul's questions?
I still have no redirect for Mr. Sidler.
Okay, Mr. Sidler, you are excused, sir. Thank you for joining us today.
Thank you.
Thank you, Jack.
I believe that is the evidentiary witness portion of the proceeding has been complete with Mr. Sidler. Now we can discuss briefing schedule, unless there's anything to address before that.
Mr. Hearing Examiner, I think I had already admitted Bruno Exhibit 15, but if not, the one we talked about with the abstract was in bold there. Can I admit that if it's not already admitted?
Well, I would certainly object to that.
Yeah, I'm not gonna do that, Mr. Bruno. If it's been admitted, it's been admitted. And if you fail to do it during the course of your presentation of evidence, it's not the commission's problem. Sorry, sir. I'll just share the screen. I went over this. I think this will be the easiest way to talk about it. So PNM had requested an expedited transcript. And I think Mr. Lee will likely have the transcript to us before the 31st, which is 6 days from now. But if you assume that, then here is the schedule that flows from it. And it's not necessary that you all write this down. I'll issue an order commemorating it. If you want to write it down, feel free. So we'd be looking at initial briefs, April 20th, response May 3rd. And then, these rest of these dates that flow are just more aspirational than anything. But I mean, I think you can see that even if I'm able to issue a recommended decision by June the 3rd, that effectively leaves a week for the commission. So this is a very, and again, the commission action requested by July the 3rd was a PNM request, if I understand. Is that correct, Ms. Padilla?
Yes, Mr. Hearing Examiner.
Well, it's a pretty tight schedule. I can't tell you if that's going to actually happen.
It is a tight schedule, but no, we do appreciate all of your efforts. What I would suggest we discuss is possibly discussing whether folks really do want the full however many, like almost 4 weeks until April 20th to do that initial brief. I know PNM is a little different. We probably have more resources than other parties do, so totally just would like some discussion on that point, but that may be one area where we can move it up a little. But I'm not involved in ongoing rate cases or anything, so I know the pressures on my work, I might not have the same conflicts as other folks may have. Actually, I am on that rate case. Never mind.
I mean, I got to say, Ms. Padilla, my answer to that is, that 20 days is going to be super valuable just to the commission. I mean, we've got motions in the rate case to deal with. I mean, this is just, honestly, I feel like this is as fast as it's going to get done. And I don't know that it's realistic for PNM to anticipate this gets resolved by July the 3rd, frankly. I mean, we can try, but I have my doubts.
So is that July 1st date here? That's P and M's request?
Yes, because then I think the idea would be it gets resolved within the first week of July at an open meeting or something.
Okay.
That this is being driven by PNM's request. There is no, of course, statutory deadline that applies here. They've held off from filing an advice notice. So that's out there.
Okay.
Mr. Gould, go ahead.
I apologize, I interrupted you, so why
No,
don't I?
that's okay. You go.
Would it be helpful for the parties, if they wish to have a date to propose findings and conclusions for your recommended decision?
No, probably not. It's not the hassle of writing it. I mean, the writing process is part of actually absorbing it all. I feel like, that's, you don't actually fully understand a case until you've written the thing. So I appreciate that, but no, I'm not, I mean, for me, it's not so much me. I mean, look what this does to the commissioners, right? Like, even if we do this in like no time, I mean, 30 days is not a lot of time for recommended decision writing. I can start on it now, but like, I mean, none of this is slow. This is as fast as it gets.
Right.
This is as fast as it can possibly be done. And then the commissioners have a week. And I don't think that's going to be adequate. And that there's a lot to talk about still. I mean,
the only thing I think I could offer, Mr. Hearing Examiner, again, is perhaps moving up the briefing schedule by a week with initial briefs due April 14th. But I completely would defer to all of my colleagues who, maybe may have fewer resources and other demands, but because it does seem like a fairly generous amount of time to get the initial brief completed.
We would object to that, Mr. Hearing Examiner. It's, as Ms. Padilla recognized, that a lot of us are either single attorneys or we only have one other person helping us. So that, just to absorb all this and to provide you with a brief that is complete with all of the necessary citations to the 5-day record and to the, I don't know how many exhibits. It's going to take some time for us to wade through that. And we think it would be the most helpful is to have the time on the front end. So those initial briefs are very complete and do cite the record extensively.
yeah, I mean, I can understand. Mr. Gedko, you had your hand raised, and then Mr. Albright.
Well,
Go, Mr. Gedko first, then Mr. Albright.
I agree with what was just stated by Mr. Gould. And I also note that if initial exceptions are filed on the 16th and responses to exceptions are due on the 24th, that would actually slide to the 26th, but that's the first day of the SPS rate case hearing. And so our office is going to be extremely busy between the 19th and the 30th. And yeah, the SPS race case starts on the 20th. So if, given the unrealistic nature of the deadline of July 3rd overall that you've expressed, it's, I'm influencing things to stretch to provide a little bit, we use a little bit of July. It's yet to be determined where the PNM rate case is going to go because of the fact that the commission moved the SPS rate case exactly where the PNM rate case was going to go. We know that's going to move somewhere.
Okay, fair enough. Thank you, Mr. Gedko. Mr. Albright?
I would just iterate what Mr. Gould and the Mr. Getgo have proffered before to the commission here. I think it's just too constrained given the other proceedings that are ongoing, not to mention, requests that are on pending before the Supreme Court on some issues.
Right. And so again, the dates that I've presented here on screen, some of these are well, not dictated, but this is just flows from, and again, the expedited transcript may be done slightly earlier than 31st. That's fine. I'll have a conversation with Mr. Lee after we conclude about when he thinks he'll have it completed, but I'm not going to pressure him to do it and any faster than he can. So I just picked the 31st as like should be 6 days, should be enough. So then from there you get 20, and then from the initial you get 13 for the responses. I entirely agree with the interveners. That's the minimum amount of time you all would need. And I'm not inclined to change that at all. And then that 6/3/23 date for the RD, that's purely aspirational. You have parties deadlocked on significant policy matters here. It's a really fun case in some ways because like you all disagree inherently. This is not we haven't seen stipulation, and I think the evidence revealed why. These are real meaty, good questions. And so I don't think it's in the commission's interest to rush anything. But I do want to say for the record, Ms. Padilla, and for PNM's benefit, we understand the desire for things to move quickly, and it is never my intention nor the commission's intention to drag our heels. But we also, Charlie Daniels once told me, a former Supreme Court justice, who I might add, on his deathbed was issuing opinions, which was really wild. He literally signed them as he was dying. The opinion's not done till it's done. And it's better to be correct and thorough than it is to be quick and sloppy. And that's not his exact words, but it's the paraphrase. So we're going to do everything we can to get this done within the time frame desired by PNM, but we're going to do it right. So I think my inclination here is just leave this as it is.
Yep.
This is the aspiration. If hopefully we can do it, but we just don't know.
Mr. Hearing Examiner, I don't know if your practice is to include a procedural history in your recommended decisions, but PNM could include a proposed procedural schedule with our initial brief, if that would be helpful to you.
Yeah, that's fine. We've had, it's interesting to me when you coming from the New Mexico appellate courts where, brevity and sort of presentation in the most efficient fashion is what's privileged. I wonder sometimes if a lot of the sort of formulaic things that appear in some of these recommended decisions, I understand their value from the trial court's perspective for sure, but oftentimes I find myself just skimming them and wonder what they're actually doing. So I don't need that, Ms. Padilla. I appreciate it.
Okay.
For me, it helps me focus myself back on the significant events. And I'm very territorial about my writing, so let's just leave it at that.
Understood.
Yeah. Anything else?
Mr. Hearing Examiner, Keith Hyman with the Water Authority. Are you going to be issuing topics you might like to see addressed?
Indeed, I am.
In your briefing order?
Yes, I have been making my notes as I go. I have lots of questions, which I won't ask unnecessary questions, but we have a brand new law. And I think there are meaningful legal questions embedded in that thing that touch upon the subjects that we've dealt with here. And I suppose you all probably feel the same way. Yeah, Mr. Gould.
Just a process question. You would like those briefs that are sent to you in Word as well as PDF in case you want to cut and paste?
Yeah, this is another. Technically, we could all just operate in Adobe. I think this convention, it is useful, and it's obviously it appears in procedural schedules, and I'm sure it's for good, or procedural orders, and I'm sure it's for good reason. The inclusion of a Microsoft Word document and everything for cutting and pasting. But, I don't know how often I actually go to the Word documents that you all are supplying. Do you find that to be, and I think, continue to do as is directed in the procedural schedules, but Mr. Gould, let me ask you, is it a pain for you as an intervener to supply that additional Microsoft Word document?
No, not at all. But what we'll do, and again, I'm not technically adept, but I will make sure that our office manager, who is, when she saves it to PDF, makes sure that it's a a copyable document that you can go in and extract text or citations if you
The
so
real
desire.
trouble, the more important part for why Word is really important sometimes, a Word format of a document, is when you're going to utilize charts. Any tables or anything that is in PDF oftentimes will not convert over through a copying function, and it just gets crazy. So that is sometimes if a writing is heavily table oriented or figures or pictures or whatever, Word documents are super necessary. So I think at this point, I'll say, yes, let's just supply Word documents as you always have. But I'll have to talk to their hearing examiners about that as we go forward. Like, is it really all that useful to us? And is there maybe a better way of doing it? I don't know.
Well, sometimes I find that it doesn't, that when I cut and paste from a PDF, I lose the formatting is what
Yeah, no, it gets
Yeah,
confusing
okay.
between the two programs, and we're all operating in Word. So, yeah.
Thank you.
I would just note that for sake of our support staff, and I happen to be breaking in a new legal assistant, the uniformity, especially among the hearing examiners, is greatly appreciated. And when the hearing examiners start all requesting things done different ways for different hearing examiners, that adds to complications for us.
Yeah, and this is why I'm saying don't change. Just we supply the native format document. But I just wonder. I thought that was something that was that bothered you all. Then we could reevaluate. But I guess what Mr. Gould is saying is that's not the case, and maybe Mr. Herman, you can comment. That's not something your new person is complaining about.
No,
just
she
wanted to
just
email-
always has questions about how to do things, and frankly, my old assistant Jody, she's still here. We brought on some other attorneys anyway. She always has questions about how things are supposed to be done, and I don't even know all the answers to those questions. So,
Yeah.
for the sake of having uniformity, that's always appreciated.
Thank you very much, Mr. Gedko.
No, I wanted to be lighthearted. It's not the right time. Thank you.
Okay.
Sorry, Mr. hearing examiner, could you scroll down and let us see the dates again? I didn't take good notes. There we go. Okay, thank you.
Well, and I will put this in an order as well as my brief. And I had some of those little briefing questions that I was writing down.
Okay.
I have another document too, but I have to compose my thoughts further. But this will all end up in an order. You'll get it, and I will try to get this out as fast as possible.
All right.
And
Mr.
I
Albright.
just wanted to clarify on that schedule. The only dates we can really control right now are the initial briefs and the response briefs. And you'll take the time you need to write your RD, and the commission will act on the
In the
date
time it
does,
needs.
but the exceptions and the responses to exception, those aren't any deviation from rules.
No, and this was me just trying to chart out like what does the world look like with these dates. So yes, correct, exactly, Mr. Herman. Mr. Albright.
Mr. Hearing Examiner, right, I understand that these are the dates that you're going to order out. I would just, given the likely length and depth of the initial briefs, I'm not sure that the 13 days for responsive briefs is realistic, or at least I would, let me rephrase that. Might be somewhat realistic, but some additional time there would be helpful.
Right. Well, I think, Mr. Albright, if those come and there are interveners who require more time and can show, understandably why that's so, you can always file a motion. I don't see why that would be a problem.
Thank you for that. Appreciate that.
Yeah. I mean, if Mr. Gould.
And somebody mentioned this before. I think the 24th falls on a Saturday. So you're for the response brief, June 24th, is that going to be corrected to June 26th?
And again,
Yeah,
this, just for clarification, Mr. Gould, those dates there is just purely a hypothetical. The only dates that are concrete are for initial briefs and response briefs. Am I going to get a recommended decision circulated by June the 3rd? I have no idea. That will be largely contingent upon how much you all write and how much you argue about. So we'll have to just wait to see that. So again, the initial exceptions, response to exceptions, and commission action were just laid out on a piece of paper for discussion purposes to show that there's not really adequate time to get this done by the 1st of July, frankly. Maybe this will happen, but we'll see. Anything further?
I have one really quick one as one of the pro se interveners here. Is there a how to write a regulatory brief for dummies that I can read?
You know, unfortunately, I do not think so, Mr. Baker. I mean, my recommendation would be if you know how to utilize, or have you been able to utilize the commission's e-docket service?
Yes, and I was planning on just going and looking at some, but I didn't know if there was any more structured, like, here's what can go in, here's what cannot go in.
That's a much deeper conversation. But what I would suggest to you is just go take a look at some of the briefs that exist in e-docket, and imitation is the most sincere form of flattery, as they say.
Okay, thank you.
If there's nothing else, we will close the Mr. Albright, before we go.
Just one final comment. I want to thank the court reporter once again, Mr. Lee, there for his stick-to-itiveness and diligence there. It's been a pretty intense hearing, or very detailed, and appreciate his efforts.
Okay, so we'll close the evidentiary record, and Mr. Lee, we are off the record in this case. Okay, everyone, thank you very much for participation. I enjoyed myself. Pro se interveners, thank you for your contributions, and till next time.
Thank you, Mr. Hearing Examiner. PNM really appreciates everyone's participation and all of your contributions to our case.
Thank you, Ms. Padilla. Good afternoon.